open session. You want to go ahead and
Yeah.
get started?
Father, we thank you today for your loving kindness and your multitude of tender mercy, and you continue to watch over us, keep our family, continue to bless these commissioners, each one and their family, and our citizens within our city. We ask this in your son Jesus' name. Amen.
Amen.
I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Hey, everybody. Thank you for coming out today. I love how we can fill rooms.
Today is going to be laborious. We need to step through this, but sort of to set the context, this is not something we have to finish today. It's a long document. The first 14 and the last 14 pages of this packet are just things like the table of contents and definitions and so forth. So, but there are 40 pages of the document, and we've got 3 hours set aside, and we can do 1, 2, or 3 hours. It's up to you. We can finish this another time. The idea is just to begin the process and start moving through it. We did do some research in the city of Winter Haven. I found some communities like Bradenton that just adopted it in its entirety. Winter Haven adopted it and then took out the sections I guess they didn't like or need. So I've got a copy of that as we go through. I'll let you know. For instance, they eliminated a section on Board of Appeals. They don't have that. And they eliminated a section on fines. It was a very small section. So I'll bring that up as we go through. So we may look at a section and say we don't need that here in our community. We don't have that process or that board or whatever, and we can eliminate those. But it talks about an adoption. There are 7 areas called out where we have to insert a name of our city and so forth in this code. It's pretty simple. And I have reached out to them in terms of their copyright needs and so forth, what we might have to pay an annual something to keep it on our website and that sort of thing. So we'll get all that squared away before we adopt it. But today is to go through the rules and see what we want to keep in there and what we want to strike. And I think it actually starts the 1-1, Chapter 1, Scope and Administration. Section 101, we'll just go one section at a time.
Well, maybe before we get started, could I ask a question?
Yes.
Okay, so this is a question that I have, the role of the code board. It seems to me that that would be something that maybe Bobby could look at what this document says and what our current code says, and then make a recommend or explain to us how they would fit together or not fit together. Because I don't think this document references a code board. And then my other overall question is, what it would be helpful to know what we would be taking out of our current code to give it some context. I'm assuming that this would have to dovetail somehow or replace in part Chapter 6.
Well, once we figure out how much of this we want to keep, I think then we can do the exercise of how it dovetails with what we have.
Well, but I don't even understand what we have, because if you look in 6.3, the Declaration of Required Codes, it talks about this is in our code ordinance, says the 2007 Florida Building Code, and then it also references the 1994 edition of the Standard Housing Code as promulgated by the Southern Building Code. And of course, 1994 was a long time ago, and I may have gotten this wrong. I thought at one point that our code officer, and forgive me if I have this totally wrong, because I usually do, it was my understanding that our ordinance says that we had a building code but no housing code. But this does reference the standard housing code. So, I mean, it would be helpful to know before we got started what all these things pertain to. And is this minimum maintenance standard something that people are using to replace these things, or does it go in addition to?
I think they're in addition to, and so we'll still have the Florida Building Code, which we don't have a choice. We'll have
Right.
our code. Once we've figured out what we want from this document, we can look at our code and see if anything that's duplicate, we can strike. So when we do for adoption, we would put in there, like you said, which this eliminates section 1, 2, 3 of this part or replaces it and so forth. So the first step, I think, is to figure out what you like in this code and what we're going to adopt.
That was my understanding, is that's what we were supposed to be doing, is to go through this and determine what in this that we like, that we would like to make sure that the city has within our code, and then do that, do the comparison after the fact to see what we already have and what we need to add.
Well, that's a very technical thing, because our code is very short. It's not very specific, but it incorporates by reference the entire Southern Building Code. So are we also going to go through the whole Southern Building Code?
No,
No,
And who will do that for us?
we're not going to go through, we will adopt this in addition to the Southern Building Code. I don't believe we have a choice on the Southern Building Code.
Well, but it says the standard housing code as promulgated by the Southern Building Code.
Okay.
That's different from the Florida Building Code. In other words, I don't think we have an understanding of what codes we have to follow now.
well, I think what we're gonna do right now is we're gonna get started with this. Let's get through this, we got a lot to go through.
Yes.
And then, like Charles said, this is not something that we have to do right away. This is just starting these conversations. Where do we want to see the city go with this? And this is probably gonna take, it might take a couple of meetings.
Yeah.
You know, this is a lot to digest for everyone. Us, Pam, Charles, Bobby, everybody to digest. So, but at some point, we gotta get started in it. So let's go ahead and get started.
Okay. Well, 101.1, the title, it says the 1-1.
1-1, keep going. It's going right here, see where it says right here? It's 1-1.
It says these regulations shall be known as the International Property Maintenance Code of the City of Crescent City. And what Winter Haven did was, these regulations shall be known as the minimum property maintenance standards of the City of Winter Haven. So we don't want to say this is the International Property Maintenance Code. I think someone mentioned to me, they wondered if we changed it enough, would it no longer be the international property? So if you want, we could say this will be the minimum property maintenance standards of the City of Crescent City. Herein refer to it as this code.
Well, I would think that would be a question for our city attorney, as to how we're supposed to incorporate this.
I think it's a preference. What you're
Well,
Well, what you're running into is this is copyrighted, so they've got a copyright on this, and they call it the I code. So in the reference and everything that they do with this, they're calling it, my take on it, they call it the I code. There is a copyright. So the question is, you know, if you start to manipulate it, what does that do? What does that do to this document? Does it become just ours, or can we still reference the international property maintenance code?
Right.
And I think what Charles is saying is that, like what Winter Haven did is.
They took chunks out.
They
so
took chunks out. They were able to take chunks out. That's something they also say that you can contact them and they can help you with the implementation. They've given a contact to reach out to them and they can help you with the implementation.
So I'll get input back from them if there's any problem with us making that change. 101.2, the scope, the provisions of this code shall apply to all existing residential and non-residential structures and all existing premises, and constitute minimum requirements and standards for premises, structures, equipment, and facilities for light, ventilation, space, heating, sanitation, protection from the elements, a reasonable level of safety from fire and other hazards, and a reasonable level of sanitary maintenance. Responsibility of owners and owners' authorized agent, operators, and occupants the occupancy of existing structures and premises, and for administration, enforcement, and penalties. That seems pretty straightforward. The purpose of this code is to establish minimum requirements to provide a reasonable level of health, safety, property protection, and general welfare insofar as they are affected by the continued occupancy and maintenance of structures and premises. Existing structures and premises that do not comply with these provisions shall be altered or repaired to provide a reasonable minimum level of health, safety, and general welfare as required herein. And if this section, subsection, sentence, clause, or phrase of this code for any reason held to be unconstitutional, such decision shall not affect the validity of the remaining portions of this code. So I think all that's pretty straightforward.
Anybody have any questions on that?
So basically, you're saying instead of having the international property maintenance code, we would call that the Crescent City.
Or just minimum property maintenance standards for Crescent City of Crescent City. We're gonna see if there's any problem with that. I suspect that's why Winter Haven changed the name, because they took out sections of the international code.
Well, I think it's move on and
Yeah.
as well. Go ahead.
So section 102, applicability, where this is a conflict between a general requirement and a specific requirement, the specific requirement shall govern. Where differences occur between provisions of this code and the reference standards, the provisions of this code shall apply. Where in a specific case, different sections of this code specify different requirements, the most restrictive shall govern. I think that may clear up some of the questions between codes. Maintenance, equipment, systems, devices, and safeguards required by this code or provision, previous regulation or code under which the structure or premises was constructed, altered, or repaired shall be maintained in good working order. An owner, owner's authorized agent, operator, or occupant shall not cause any service, facility, equipment, or utility that is required in this section to be removed from, shut off from, or discontinued for any occupied dwelling, except for such temporary interruption as necessary while repairs or alterations are in progress. The requirements of this code are not intended to provide the basis for removal or abrogation of fire protection and safety systems and devices in existing structures. Except as otherwise specified herein, the owner or the owner's authorized agent shall be responsible for the maintenance of buildings, structures, and premises.
Pretty straightforward. Any
Yeah.
questions on that? Okay, anyone?
Application of other codes. Repairs, additions, or alterations to a structure or changes to occupancy shall be done in accordance with the procedures and provisions of the International Building Code, International Existing Building Code, International Energy Conservation Code, International Fire Code, International Fuel Gas Code, International Mechanical Code, International Residential Code, International Plumbing Code, and NFPA 70. Nothing in this code shall be construed to cancel, modify, or set aside any provision of the International Zoning Code.
Is it possible that you can put, like, Putnam County Code or Crescent City Code instead of all the international? Or do we have to leave the international bloody-blahs in there?
Let me show you what Winter Haven did. Repairs, additions, or alterations to a structure or changes of occupancy shall be done in accordance with the procedures and provisions of Chapter 553 Florida statutes and any applicable building codes, including but not limited to the Florida Building Code. Nothing in this code shall be construed to cancel, modify, or set aside provisions of Chapter 553 Florida statutes or any applicable building codes to a particular project, including but not limited to the Florida Building Code or any reference standard therein. So they took out all those other codes.
That's what that was gonna be my recommendation
Right.
too.
So
And
it
then we
sounds
might wanna
nice.
add something in there about the county too, that if the county might
Right.
have some additional, the county might have something, in there.
Other county codes that we deal with? I think they use.
Well, from
Florida.
from a construction standpoint, I don't know if they have any additional codes that they might add on to it. You can always add more, you can't take away from.
Repairs, additions, or alterations to a structure or changes of occupancy, isn't that also part of our county code? Those items, or is the county code and the Florida code the same? That's the
Well, the
question.
Florida Building Code is the Florida Building Code. They may have,
They may have added some
Okay.
more things that are more stringent in Putnam County, but they would have to at least adopt.
they wouldn't be applicable in the city.
You know, it's-
Yeah,
Okay,
Right now, it would be applicable, so I don't think it would be applicable.
except for the fact they do our inspections. So we work
That-
under,
and yeah.
that's, they do our inspections.
Okay.
Any more questions on 102.3?
I would think that Bobby and Pam, and that we should ask even the county about this. We need some expertise
We
here.
will as we move about, this,
Yeah.
we're taking notes to do that.
Yeah.
We don't need to,
We,
yeah, it's
No.
not set in stone here, this is the discussion. This is why we're
yeah, I know, I'm aware of that, but it's not really up to our expertise to decide what to drop in and what to
We're not
drop out.
deciding anything, Lisa.
Okay, Charles and I talked about this earlier today. We talked about this, because as you get more into it, you're gonna see that there's other, it's not just Pam. There's gonna be other agencies that are going to be involved in this. So what they're going to do, it's my understanding, is they're going to, all of those bodies are going to come together and meet to see who's gonna be doing, who would be doing what, once we kind of determine what direction we're gonna go.
Yes, I would assume so. So I would assume there'd be a staff recommendation about what to put in here. We don't have the
Lisa, we don't
expertise.
have a staff recommendation right now. Right now, we're
No,
going
just
through
discussing it.
this to
Okay.
discuss it, to see what we
What we
feel
need to do.
our recommendations would be,
Based on
what we
just
see in
whatever we want.
this.
Okay.
So, okay, let's move forward.
Existing remedies. The provisions in this code shall not be construed to abolish or impair existing remedies of the jurisdiction or its officers or agencies relating to the removal or demolition of any structure that is dangerous, unsafe, and unsanitary. Workmanship, repairs, maintenance work, alterations, or installations that are caused directly or indirectly by the enforcement of this code shall be executed and installed in a workmanlike manner and installed in accordance with the manufacturer's instructions. Structural analysis, where structural analysis is used to determine if an unsafe structural condition exists, the analysis shall be permitted to use normal strengths,
Nominal strengths.
nominal loads, load effects, required strengths, and limit states in accordance with the requirement under which the structure was constructed or in accordance with any subsequent requirement.
Okay, is everyone so far at this point, as we turn the page, everyone good with that page?
Yes.
So we're gonna move forward, okay?
Historic buildings. The provisions of this code shall not be mandatory for existing buildings or structures designated as historic buildings, where such buildings or structures are judged by the code official to be safe and in public interest of health, safety, and welfare.
Okay, everyone good with that?
They made a change in Winter Haven. Provisions of this code shall not be mandatory for existing buildings or structures that are designated as historic by the National Park Service and listed on the National Register of Historic Places when such buildings or structures are judged by the code official to be safe and in the public interest of safety and welfare. So they specifically said it has to be on the National Register.
I actually would probably recommend that if we could use that language that Winter Haven has used. I think that will give some, that'll clarify.
Well, Mayor, if I could, please. I think that would really hurt us in our historic buildings because we have a historic district and there are contributing structures in that district. We don't have many buildings that have been specifically designated by the National Park Service. As well, we have historic buildings that are not within the historic district, but they are very historic buildings from an important period. And apparently we have an ordinance that allows us to designate historic buildings. So to me, that wouldn't really help our historic buildings to say they have to be designated by the Park Service. That at least we should say that they would be eligible to be designated under our code, or that they are designated under our code. I mean, that would
Okay.
really help.
Okay, commissioners, we've got, this is something for discussion. Yes?
Well, if we exempt, essentially this is an exemption for historic buildings, I think it'll exempt a lot of the buildings we may be looking to improve that are
That's my concern as well.
abandoned and
Yes.
That's my concern as well. They
Okay.
they
It
would
doesn't-
use this against what we're trying to do rather than help us
No,
and improve.
actually, no. Okay, there's two things that I think apply here. says the provisions of this code shall not be mandatory for the existing buildings or structure designated as historic. It doesn't say it doesn't apply. It says it shall not be mandatory.
That means it doesn't apply.
No, that's not what that means in this situation. And
Yeah,
as well, there is a provision somewhere else in here that allows the code officer to make exceptions. So I think the language that says it shall not be mandatory, if it didn't apply, I would say it doesn't apply. Not being mandatory, I think, means that you can give leeway to historic buildings. I don't think it requires you to ignore all safety hazards or whatnot.
I think you have to read the whole sentence though.
It is.
You really do. You can't just stop it right there. You know, it says for existing buildings or structures designated as historic buildings where such buildings or structures are judged by the code official to be safe and in the public interest of health, safety, and welfare.
Yes.
It basically is just saying, in that case, it shall not be mandatory. If everything is judged to be okay, if you go into a historic place, and maybe I'm reading this wrong, if they
Well,
judged it to be okay to go in there,
Too, so Commissioner DeVito, I'm gonna ask.
then I think,
that.
I think it can be left the way it is.
My concern is, an example is a house over here, I think it's an empty house in Florida,
Can you speak into?
in Maine,
Okay.
Florida, Maine, I think it's sold and it's gonna sell again. It's kind of falling apart.
Yes.
And so I'd hate to see that, well, it's a contributing structure, so we can't do anything about the lack of maintenance. It's not mandatory for them. We could say, we really want you to fix it up and paint it, but because it's a contributing structure, that's not mandatory. That's my concern, that we would take the wind right out of our own sails.
I agree, I wanna make sure that with whatever we do, it cannot be used against us trying to do what needs to be done in a fair and just way.
I mean, in my opinion, that leaves the discretion with the city, whether you wanted to enforce it or not. It's not mandatory that you have to enforce it. If the code officer also concludes that it's safe
Yeah, if they say it's safe.
and in the
they
public
go in there.
interest of health, safety, and welfare, so, you wouldn't have to apply it. But it doesn't, I don't think it would give somebody the ability to walk up here and say, 102.7 is not mandatory to apply for me, so I can do whatever I want. I don't think that's how,
No, it's
that's not how I would construe it. It would be, the discretion would be left with the city, not the owner.
That's what I said.
I suppose.
And the problem is that there are a lot of interior requirements in here. This is specifically not talking about safety or health, safety, and welfare. I think it is allowing leeway to waive some of the very specific interior requirements, which would probably be more suitable for modern buildings.
I don't know, I go to a lot of historic buildings, very safe, very good. You know, I'm not sure what we're talking about here. I think that 2.7 should be as it stands. That's just my opinion.
Okay, so you like the way it's currently written?
Yeah, because
Okay.
because you need,
No, that was,
you,
well, that was the question, was,
yeah, you need the code official
Okay.
to
Sounds like
say,
Commissioner
Say-
DeVito, you're in agreement with that, with 102.7?
That's what I
Okay.
said before.
Okay.
I think it's just fine.
I don't think it's
Okay.
about the same. I'm not sure.
Okay, so if everyone's in agreement,
Sounds like
sounds
it.
like Commissioner Banks is, okay, let's move on. Reference codes and standards, let's move on.
The codes and standards referenced in this code shall be those that are listed in Chapter 8 and considered part of the requirements of this code to the prescribed extent of each such reference and as further regulated in sections 102.8.1 and 102.8.2. And they're talking about Chapter 8, which refers to reference standards, which is there's probably a list of.
And some of this Charles did like Winter Haven, did they keep that in there, or did they take some of this language out that just kind of,
In reference chapter 8, is the codes and standards referenced throughout this code shall be considered part of this code and are accordingly adopted and incorporated herein by reference to the prescribed extents of such reference. Where differences occur between the provisions of this code and reference standards are more stringent. So it's the same language that was used earlier. So for instance, that list of standards is like for fire extinguishers and other things, it's just saying those are hereby adopted by reference. Exception is where enforcement of a code provision would violate the conditions of the listing of equipment or appliances. The conditions of the listing shall apply. And conflict, where conflicts occur between provisions of this code and the reference standards, the provisions of this code shall apply. And provisions in reference codes and standards where the extent of the reference to a referenced code or standard includes subject matter that is within the scope of this code. The provisions of this code, as applicable, shall take precedence over the provisions in the reference code or standard. So it's just clarifying when you've got other types of codes involved on appliances and equipment and so forth. Which one prevails?
okay. Is everyone good with that?
Yep.
So which one prevails?
Well, depending on where conflicts occur between provisions of this code and the reference standards, the provisions of this code shall apply. And to the extent where the reference to a reference code, to the extent of the reference to a referenced code or standard includes subject matter that is within the scope of this code, provisions of this code, as applicable, shall take precedence over the provisions in the reference code or standard. And then where enforcement of the code provision would violate the conditions of the listing of the equipment or appliance, the conditions of the listing shall apply.
See that
Yeah.
Yeah, I understand.
Okay, let's move on to 102.9.
Requirements not covered by the code. Requirements necessary for the strength, stability, or proper operation of an existing fixture, structure, or equipment, or for the public safety, health, and general welfare not specifically covered by this code shall be determined by the code official. In this case, if it's structure, that would be the building official.
Yeah, I was gonna say, yeah.
Okay.
Would we want to say would be determined by the code official, something to the effect that of wherever their purview is, wherever their,
We could say the appropriate
the
code official.
appropriate,
Yeah.
the appropriate, okay. Okay, everybody good with that? Any questions? Okay, let's move on, 102.10. Commissioner DeVito, do you have a question? We'll take public comment at the end if that's okay, because otherwise we're gonna just be stopping and starting.
Well, this is a workshop. It's not supposed to be you guys present everything and at the end we get comment.
We're not presenting everything, we're discussing it among commissioners. If y'all wanna take public comment at this time, I'm gonna leave it up to y'all. So, everybody in favor of public comment, or do you wanna wait until we get through this first chapter?
Let's wait till the end of each chapter.
Let's do that.
Okay.
This is very, very long.
Yeah, this is long, it's,
And
there's a lot
laborious.
to it here.
So we will at the end of, and I was intending at the end of each chapter, because categories.
Okay.
References to chapter or section numbers or to provisions not specifically identified by number shall be construed to refer to such chapter, section, or provision of this code. And the provisions of this code shall not be deemed to nullify any provisions of local, state, or federal law.
Okay.
Is everyone good with that?
Yep.
Okay, part 2, section 103, code compliance agency. Creation of agency. And in this case, the Winter Haven had code enforcement unit because they already had a code official. So what the standard says is the City of Crescent City Code Enforcement is hereby created, and the official in charge therefore shall be known as the code official. So we don't need that. The function of the agency shall be the implementation, administration, and enforcement of the provisions of this code. The code official shall be appointed by the chief appointing authority of the jurisdiction. And I think we could probably strike.
Are you saying we don't need this agency, basically?
What Winter Haven did was 103.1 is called code officials. Each code enforcement officer of the city is deemed a code official for the purposes of this code. Any notices required to be delivered to the code official under this code shall be delivered to the responsible code 103.2 was deleted. 103.4 liability, which is something we add in accordance with Florida Statute 768.289A, Florida statutes. A city official or employee charged with the enforcement of this code shall not be held personally liable in tort or named as a party defendant in any action for any injury or damage suffered as a result of any act, event, or omission of action in the scope of his or her employment or function, unless such officer, employee, or agent acted in bad faith or with a malicious purpose or in a manner exhibiting wanton and willful disregard for human rights, safety, or property. That was probably added by their attorney.
And they have, there's, as you get further down into this, it talks about them not being liable in the enforcement of their duties, and not being liable in this code, yeah. So they just went ahead and, I guess, established their own language.
For code enforcement. I can provide you with that language to replace section
So
103.
let's go backwards for a minute here, because you jumped from 103.1, now we're down into 105, I believe.
No, we're still in 103.
He was just saying what Winter Haven had done in their one, in their one.
It sounds as though they've kind of moved along.
They
They may have
did.
merged some of the duties and powers of code official.
So my first question is, it sounded like you didn't think that we needed a code official.
No, I think we could mirror what they did, where we say our code enforcement officer is, when
Because,
this code says code official, that's who we're talking about.
okay, so how would you put that in this? It would be the code enforcement officer, not code official?
Actually, let me think about it, because the building code official will handle building code issues.
Yes.
I called him about who is this referring to, and he said it's both himself and our code officer, depending on the infraction or whatever it is.
Yeah.
Overgrown property or that sort of thing, it'll be a code official if it's,
So
The
code
board
official
just
can be both.
we'll have to have some
Code
language
official,
that distinguishes that, the appropriate code official.
Okay, that makes sense then.
So we need language for that.
And then 103.3 says deputies. We can go ahead and deputize, or we don't really need.
Or we can strike that.
We can strike that, okay. Is it that, I don't think it works for us.
Do we have any other questions on that?
I mean, if we grow, why would we strike the ability to appoint deputies? If we grow, maybe we would need a deputy, or, I don't know, this is,
If we grow, nothing's in concrete, and we can probably add it at some point in time.
right, but,
To appoint a deputy code official, other related technical officers, inspectors, and other employees. Such employees shall have the powers designated by the code official.
I mean, I don't know, to me, I am not familiar with commissions drafting ordinances in this way. Charles seems to have language from Winter Haven that he wants.
No,
It would be helpful to.
Showing you what they did.
Yes, but there's a lot of it, so it would be helpful to see it. Some of these things, we're not gonna draft all this right here. Some of these things are out of our expertise. They should be provided by people that have that expertise.
Okay. So now we're into section 104, fees.
Fees for activities and services performed by the department in carrying out its responsibilities under this code shall be established by the applicable governing authority. The code official is authorized to establish a refund policy.
do we even have a refund, we have a refund policy, Pam? Not one. We don't really even,
No.
oftentimes we don't even really much collect money, let alone have a refund policy, okay?
Maybe we might establish one.
Okay. So our fees,
So how we gonna handle that?
Well, we can strike that
basically-
whole section.
Basically, we're the governing body that would
Yeah.
approve all these
It's
fees.
just saying that you will establish the fees.
And I think that we've already done that in our code, haven't we? Haven't we established some fees
I wonder if we want to
There may be some
put,
new ones with this.
Okay,
because this is ours, I wonder if we want to put on there by the city commission.
yeah, by the city commission. Because I think we have already established some type of fees, how we
Yeah,
process,
this may be, create a new set of
yeah,
fees.
I don't know what that,
So you want more specific than applicable governing authority, you know, the city commission?
yeah,
Think
city
so.
commission for.
I do.
city, yeah.
How do you feel, Commissioner West?
That sounds
You
good.
good with that?
Right.
Yeah.
Commissioner DeVito? Commissioner DeVito,
Yes,
we,
yes, definitely.
okay, thank you. Okay, let's move on to 105, section 105.
Duties and powers of the code official. General, the code official is hereby authorized and directed to enforce the provisions of this code. Code officials shall have the authority to render interpretations of this code and to adopt policies and procedures in order to clarify the applications of its provisions. Such interpretations, policies, and procedures shall be in compliance with the intent and purpose of this code. Such policies and procedures shall not have the effect of waiving requirements specifically provided for in this code. Inspections. The code official shall make all the required inspections or shall accept reports of inspections by approved agencies or individuals. Reports of such inspections shall be in writing and be certified by a responsible officer of such approved agency or by the responsible individual. The code official is authorized to engage such expert opinion as deemed necessary to report on unusual technical issues that arise, subject to the approval of the appointing authority.
Okay, do we have any questions on 105.2?
So where it says appointing authority, do you just want to always have Crescent City Commission?
And I guess in this case, it would be us, wouldn't we also have our code board.
Yeah, I was gonna say, I think in certain instances it would be the code
It
board as
would
well.
be, it might be the.
Can you guys speak into your microphones, please?
You want that one say by the code enforcement board?
I guess, the-
What
Or
you
just
got?
leave it?
The code enforcement board doesn't appoint the code enforcement officer. Who hires the code enforcement officer?
That's city manager.
right, so I guess what I'm trying to say is, since some of this is, whatever, needs figuring out as to who it actually is, but instead of saying general, we should be specific. If it's the commission, if it's the city manager, then we should say what's specific for Crescent City. Whether it's the city commission, the city manager, or perhaps the code.
So do you want the approval of expert opinion to come all the way up to you? Or delegate that to the code board or to myself,
I'd rather it come to you.
Yeah.
the city
Well,
manager?
whatever, it says the appointing authority, so I guess what I'm saying is, figure out what that is in the city, then put that in.
Well, I think it's gonna change just based on, I mean, it's gonna be depending on
What it is.
what it is and what we're dealing with, because there might be some times when it's gonna be the county, when it could be the county too.
So just leave it at appointing authority?
Yes.
Yeah, I think, yeah.
Okay.
That's good, yeah.
And this is something else that, and Charles, and we talked a little bit about this, that we need to make sure as we, if we do something with this, that our interlocal reflects this.
Right of entry, where it is necessary to make an inspection to enforce the provisions of this code, or wherever the code official, whenever the code official has reasonable cause to believe that there exists in a structure or upon a premises a condition in violation of this code, the code official is authorized to enter the structure or premises at reasonable times to inspect or perform the duties imposed by this code, provided that if such structure or premises is occupied, the code official shall present credentials to the occupant and request entry. If such structure or premises is unoccupied, the code official shall first make a reasonable effort to locate the owner, owner's authorized agent, or other person having charge or control of the structure or premises and request entry. If entry is refused, the code official shall have recourse to the remedies provided by law to secure entry.
I don't think that they should be able to walk right up and say, hey, I'm the code guy, you know, let me in. I think that you should have, like, most generally, if you rent, right? If the landlord wants to come into your place, you gotta give at least a 24-hour notice to say, I'm on my way, I wanna come in. And that's just being courteous.
Okay, matter of fact, code?
Sure.
Place.
All right, this is very general because it's international. It could apply in jurisdictions, I guess, all over the country or anywhere, maybe internationally. We're obligated to follow the law.
Yeah.
Whatever the law is, we have to follow it. So that's why it's very general, I think. If entry is refused, the code official shall have recourse to the remedies provided by law to secure entry.
Right, the last sentence.
So,
does take
I
care of
mean,
that.
Florida law applies, correct, Bobby?
Yes.
So, and what is the law now? Because it's my understanding that we're very limited as to what action we can take for
I don't-
interiors.
I don't think that if our code enforcement officer or whoever it is goes and the person that owns the house or is in possession of the home says, no, you can't enter that house unless you get a court order saying that you can enter that house.
That's what I'm saying. So
That's
that's,
what
so
this
that's
says.
Florida law.
Yeah.
However, one thing I've been wanting to ask about is, and this dovetails with,
Right.
With landlord
It's
tenant.
sentence.
with leased premises. Bobby, isn't it possible if a municipality or a county has specific requirements for, and I think there are some in here, has specific requirements for leased premises, that, to get a certificate of occupancy or keep their, ability to lease the premises, doesn't a landlord have to allow inspections to show that legal standards are met?
I'm not, off the top of my head, I'm not sure about that.
I'm not sure.
Can we find that out?
To our apartments that we have in Crescent City, Gummy Court and the other ones, they have to notify the occupant.
Yeah, you gotta.
Yeah.
You got to notify the occupant.
Usually the lease has it.
Yeah, right. That is on the lease, that'll give them 2 or 3 days. I just remember how many days it is now before they come in and inspect. But you know that, you read that contract when you, moving in.
Yes.
Yeah.
Well, this does say that present credentials to the occupant and request entry. So the occupant can say no,
No.
and that's the end of it.
And that's
And
the end.
short of a court order that he's.
That he's talking about.
And I think what Commissioner DeVito is referring to is if you're the owner and you're renting it,
Yes.
is there something that governs, that says that they have to make sure that those are livable conditions?
Habitable, in other words,
Right.
between tenants, or
Yes.
if there's a complaint, because I know some other jurisdictions have specific requirements for leased premises, and I think these do. So if it's not your homestead or your business, if you're in the business of leasing it out, I think it would be very helpful for us to know what is our ability to inspect the interior conditions of rental properties, because I think some of them are very bad.
Pam, you had some?
If someone that rents a property here in Crescent City and they invite me in, I can go in and look inside. I don't have the right to go and demand to go inside.
Right.
But I've had people that rent properties here in Crescent City call me and ask me to come in and look and show them what the code violations were, and then the property owner was cited. But I had the permission of the occupant to go into the dwelling at the time,
Yeah.
Yeah, see that?
which is
Yeah, that
legal
all makes sense.
entry,
Yeah,
because the leasee or the renter invited me in.
okay.
Right, but unfortunately, I think we have some private situations, not necessarily corporate owned, where the renter, might be too intimidated to initiate that. I don't know, I'll ask Bobby, I'll look up, whatever code it is I'm thinking of, and I'll send the question to Bobby.
I don't know how it is in Crescent, exactly how it is in Crescent City, but in St. Augustine, this was discussed a couple times, because you know, they rent the whole house to the individual, and I think they got it on their record where they got somebody comes in and expect it, because they had to put up a big, deposit to make sure, you know, so they can, if something wrong, it got to be fixed.
That's what I'm saying, that
Right.
to me, I think some of our structures, we get into trouble because we have people renting them out, and they're not really the way they should be. But, I'll make a note about that, I'll send the question to Bobby.
And that would be something, I think, too, that if we are allowed to do that, that when they're turning those utilities on, because they have to show a lease. My understanding is they have to show a lease when they're turning utilities on here at the city, that maybe that's where we could put something, do something with that, if we're having some issues with it. Okay, so are we ready to move on to, is
So
everyone
I
good?
think
so far?
5.3 is good as is.
Yeah.
Okay, 5.3 is good,
5.4,
okay.
the code official shall carry proper identification when inspecting structures or premises and the performance of duties under this code.
Okay, is everybody good with that?
Yeah.
Okay.
Pam, what do you have to show?
I have 90 cards.
All right.
The code official shall issue all necessary notices or orders to ensure compliance with this code.
Is everyone good with that?
Yeah.
Okay.
Department records, the code official shall keep official records of all business and activities of the department specified in the provisions of this code. Such records shall be retained in the official records for the period required for retention of public records.
You're
That's pretty standard.
Yeah, you're keeping all that now, aren't you, Pam?
Yes.
Okay.
Liability, the code official, member of the Board of Appeals, or employee charged with enforcement of this code, while acting for the jurisdiction, in good faith and without malice in the discharge of the duties required by this code or other pertinent law or ordinance, shall not thereby be rendered civilly or criminally liable personally, and is hereby relieved from all personal liability for any damage accruing to persons or property as a result of an act or by reason of an act or omission in the discharge of official duties. Any suit or criminal complaint instituted against an officer or employee because of an act performed by that officer or employee in the lawful discharge of duties and under provisions of this code shall be defended by the legal representative of the jurisdiction until the final termination of the proceedings. The code official or any subordinate shall not be liable for costs in an action, suit, or proceedings that is instituted in pursuance of the provisions of this code. That all makes sense to me.
I did like the language that Winter Haven did put, as long as it wasn't done in malice.
Yeah, that's just state law
Yeah.
Yeah.
for,
I mean, I wonder though if we just put that in there just to, I don't know, Bobby, you might wanna do some wordsmithing. You might wanna do some wordsmithing with that, just to make sure.
Didn't it said somewhere earlier that if it wasn't willful or?
That was in the Winter Havens.
That was in the
Yeah,
Winter Haven.
yeah.
I put it in a different section.
Yeah. Not that we would ever have a situation, but you never know,
You never know.
you never know.
Section
Everybody good
106.
with that?
Yep.
Okay.
Approval, modifications, wherever there are practical difficulties involved in carrying out the provisions of this code, the code official shall have the authority to grant modifications for individual cases upon application of the owner or owner's authorized agent, provided that the code official shall first find that special individual reasons makes the strict letter of this code impractical. The modification is in compliance with the intent and purposes of this code, and that such modification does not lessen health, life, fire safety requirements. The details of actions granted modification shall be recorded and entered into the department files.
Okay. Everybody good with that?
And just the comment, this is the section I marked out because I would cross-reference it, that would apply in the case of the historic buildings, I think particularly. That's where that non-mandatory thing would come in. There would be documented modifications.
Okay.
Alternative materials, design, and methods of construction and equipment. The provisions of this code are not intended to prevent the installation of any material or to prohibit any design or method of construction not specifically prescribed by this code, provided that any such alternative has been approved. An alternative material, design, or method of construction shall be approved where the code official finds that the proposed design is satisfactory and complies with the intent of the provisions of this code, and that the material, method, or work is offered is, for the purpose intended, not less than the equivalent of that prescribed in this code in quality, strength, effectiveness, fire resistance, durability, and safety. Where the alternative material, design, or method of construction is not approved, the code official shall respond in writing stating the reasons why the alternative was not approved. And this would probably refer more to the code of the building official.
Yeah, that's right.
Yeah.
That's good.
Do we want to put in there the appropriate code official? So that it wouldn't necessarily have to be, I mean, I don't know, I'm asking how does everyone feel about that, because the code official, when we look at it, if we're specific, our code official would be Pam, so do we want to put the appropriate did that in an earlier.
We could, because it's dealing with a building issue.
Okay, how's everybody feel about that? They good with it?
Don't have any problems with
Okay.
Fine.
Wait, so let me get this straight. We have, the county is our building inspector,
Yeah.
correct?
Yes.
Right.
And they enforce our building codes or the county's building codes?
The state building.
So,
The building code is a state.
so anything with building should probably, because wouldn't this be design, materials, design, methods, and construction equipment, that'll be the county person?
Not necessarily, because in some instances, we have, when you read through some of that, the historical, it talks about certain materials that should be used, you know, so somebody, we might have very specific that the county or the state would not require. We might say they could only put a tin roof on something and not a shingle roof. See what I'm?
That would still be a building official. I'm trying to think of.
No, it would be our, but it would be our code. That would be, our ordinance that we would have placed on that. It would still be a building,
Yeah.
the building official, but he would be enforcing our
I'm thinking
ordinance.
with Pam, for instance, I'm trying to think of something, she covers like outside maintenance. So we're saying your yard is overgrown, but they've actually planted ground cover. So they won't, when it grows in, they won't ever mow it. So that might be an instance, I'm just trying to think of an example, hypothetical, where she may say, well, because you planted jasmine, you meet the standard of the code rather than grass. I think the code here probably later says, it talks about the level of your grass or something to maintain your yard. Somebody replaces all their grass with ground cover, they're not gonna be mowing it anymore. I don't know, maybe that's not a good example, but most of them, I think they'll be the building official when we're looking at alternatives.
Yeah.
Yeah.
I think
The
we
appropriate
put
code.
too much on the code.
Yeah,
I think, yeah, we should stick with the building.
the building official.
If you wanna get her to quit, keep
And,
throwing things out.
Yeah, we keep on throwing.
Keep burying her with it.
Too much on her.
Yeah, no, I think it would be building code.
Okay. Required testing, wherever there is insufficient evidence of compliance with the provision of this code or evidence that a material or method does not conform to the requirements of this code, or in order to substantiate claims for alternative materials or methods, the code official shall have the authority to require tests to be made as evidence of compliance without expense to the jurisdiction. Test methods shall be as specified in this code or by other recognized test standards. In the absence of recognized or accepted test methods, the code official shall be permitted to approve appropriate testing procedures performed by an approved agency. Reports of tests shall be retained by the code official for the period required for retention of public records.
Well, again, haven't we put that over to the building?
In that case, the code official would likely be the building official.
Yeah. Okay.
Cause in our reading, it's saying code official, but we mean the building
The building.
official, right?
Okay.
I think we're gonna have to make some distinction in there,
Yeah.
specific to us, that when it's discussing building materials and all that stuff,
Right.
It
I
is.
think that's what we need to do.
Yeah. because I think it's gonna get.
Everything.
I just go back to, I wonder if we need to put to go back and just use the appropriate code official, because we've,
Well, that's true too.
and
You
because,
can put that-
because it might be at some point, you never know, we break away from the county and we have our own, we have our own
Well, we
internal.
can't- we
I
can't
mean,
do
you
that.
never know, you never know what could happen. That's why I was just wondering if we were just to put the appropriate code official,
Okay.
Okay, yeah.
if everybody good with that?
Okay. Is that okay?
How does that sound like that'll work? If we add appropriate code official?
We'd add that at the beginning.
Well, anywhere throughout this document, there'll be an appropriate code official, depending on which code is.
The only problem I have, or the only possible problem I see with that is that the person wouldn't be on notice of who the appropriate person was unless we said it in our code. Hey, this is the appropriate person.
And I think maybe as we get into definitions in the next chapter, maybe that's something that we can put in there.
We'll look at it, yeah. Okay. Used material and equipment. Materials that are reused shall comply with the requirements of this code for new materials. Materials, equipment, and devices shall not be reused unless such elements are in good repair and have good reconditioned and tested, and have been reconditioned and tested where necessary, placed in good and proper working condition, and approved by the code official.
Okay,
Approved materials and equipment. Materials, equipment, and devices approved by the code official shall be constructed and installed in accordance with such approval. And supporting data where necessary to assist in the approval of materials or assemblies not specifically provided for in this code shall consist of valid research reports from approved sources.
Is everyone good with that?
That's good.
Commissioner DeVito?
It's fine.
Commissioner Burton?
yeah, I'm good.
Okay.
Means of appeal, section 107. In order to hear and decide appeals of orders, decisions, or determinations made by the code official relative to the application and interpretation of this code, there shall be and is hereby created a Board of Appeals. The Board of Appeals shall be appointed by the applicable governing authority and shall hold office at its pleasure. The board shall adopt rules of procedure for conducting its business and shall render all decisions and findings in writing to the appellant with a duplicate copy to the code official.
This is something that we want to put in there that our code board, we
This
don't
could
want
be,
to establish.
this could be our code
board.
enforcement board.
Could be
Yeah,
code
yeah,
enforcement
it
board.
needs to be somebody, they have to have some type of appeal.
Right, but that's currently our code board,
Yeah.
correct?
So I would think
So-
we would want to put in there our code enforcement board.
Okay. Yeah, that's fine.
Is that everybody in agreement with that?
Yes.
Yes.
Okay.
Does not establish another, a whole other.
No,
Okay.
This is very generic.
Yes, it is
So
very generic.
This is our opportunity to put in
That's what,
what
yes.
we have.
Limitations of authority. An application for appeal shall be based on a claim that the true intent of this code or the rules legally adopted thereunder have been incorrectly interpreted. The provisions of this code do not fully apply, or an equivalent or better form of construction is proposed. The board shall not have authority to waive requirements of this code or interpret the administration of this code. The Board of Appeals shall consist of members who are qualified by experience and training and are not employees of the jurisdiction. And the code official shall take immediate action in accordance with the decision of the board. So we'll reword that to be our code enforcement board.
You know, I remember years ago, it was a funny time that we had some code that you couldn't put a well, couldn't run well water in your home. I think we still got that. I don't know exactly where it's at. In other words, if I put a well, it more or less for the irrigation.
But not your house,
Not in your home.
probably the city.
Yeah, it was.
Yeah.
Yeah, it was in the city. I don't know whether that's still active or not.
Yeah, you know, I think, I think.
It is, Pam said it is,
It's still active?
yes.
Oh, okay. I know that was, so,
I think the only thing that bothers me, is, that the people on the board need to know what they're doing. They need to be qualified to establish what is wrong, you know, if you go into a house, what's wrong with, and why isn't it in code? And when you're talking building type, it's one thing to go out and see that the yard is kept or something like that. It's quite another thing to go in and say, gee, electricity is not hooked up right. You know, everything, the polarity is off, everything's backwards. You know, so I guess what I'm saying, at one point, we talked about even having a magistrate, because we couldn't even get a quorum. And now this is acting as though, the people that need to be on the board, really have to be kind of qualified by experience and training, okay? And not employees of the jurisdiction, but anyway, but they have to have some of that experience behind them.
They have to have a background in like
I'm not familiar.
construction, architect,
Yeah.
or
Do
something
we
to
have that
that
in
degree.
for our current code?
Do we have that, Pam? I know there was some, I thought I read somewhere where there were certain requirements. What do we
There
have?
are, chapter 162 of the Florida statute dictates the requirements of the code enforcement board members.
Okay,
And they're supposed to be a realtor and like an architect and different you know, businessman, you know, I'm not specific, but
See, that worries me, that's all.
Do our current members meet all those, do we meet those requirements? I know we reduced it, so because of our size, we reduced it down from 7 to 5.
I believe they do, you know.
Okay.
But, and of course, if I can just make a comment, the magistrate doesn't have to have any specific expertise. That becomes like just a
Well,
legal
yeah,
proceeding.
but I'm just saying that we had brought it up, you know, in the past, and I'm not saying that it's gonna be brought up again, but it was brought up at one time, and
It's so Florida, the statute that Pam cited, it's like an aspirational goal, it's not mandatory. So it says the code board shall include, whenever possible, architect, business person, engineer, general contractor, subcontractor, and realtor.
Maybe we gonna got a few that serve on the board.
Yeah.
Well, that's why it says
Well,
when.
well, that's why I said,
Possible.
you know, if you lock into this, it sounds like you kind of have to lock into that. That's all.
The next section talks about that a little bit.
Okay,
Board of Appeals, membership of the Board of Appeals shall consist of not less than 3 members who are qualified by experience and training to pass on matters pertaining to property maintenance and who are not employees of the jurisdiction. The code official shall be an ex officio member, but shall not vote on any matter before the board. The board shall be appointed by the chief appointing authority and shall serve staggered and overlapping terms.
okay.
So that's what our code requires.
But, well, when Bobby comes back, I have a question for him. So, Bobby, if chapter 162 provides the requirements, doesn't it apply over the generic language in here?
Yes.
Yeah,
So we would follow chapter 162. We don't really, we should follow Florida law and our ordinance. It's my understanding.
Yeah.
Yes.
Do we want to put language in there to strike some of this language and then,
I think we could just add what's in the membership of each enforcement board shall, whenever possible, include, of our board should include an architect, business person, engineer, general contractor, and subcontractor, and realtor whenever possible.
okay.
as directed by Florida statute such and such?
Well,
Do you want to?
to me, this is Bobby's job, to make it
Well, that's what I-
right under Florida law. We don't need to be guessing for him. This is what he
Well,
does.
nobody's guessing, that's what I'm asking him. That's what we're asking him is,
I know, but you don't usually
Okay.
draft ordinances in a meeting.
Well, then we work the language and bring it back.
yeah.
That's it.
Okay, violations, unlawful acts. It shall be unlawful for a person, firm, or corporation to be in conflict with or in violation of any of the provisions of this code. The code official shall serve a notice of violation or order in accordance with section 111.4. Any person failing to comply with a notice of violation or order served in accordance with section 111.4 shall be deemed guilty of a misdemeanor or civil infraction as determined by the local municipality, and the violation shall be deemed a strict liability offense. If the notice of violation is not complied with, the code official shall institute the appropriate proceedings in law or in equity to restrain, correct, or abate such violation, or to require the removal or termination of the unlawful occupancy of the structure in violation of the provisions of this code, or of the order or direction made pursuant thereto. Any action taken by the authority having jurisdiction on such premises shall be charged against the real estate upon which the structure is located and shall be lien upon such real estate.
Bobby, do we have to?
I personally would recommend to take out a misdemeanor. I don't think we want to make it a crime because of all the stuff we have to pay for them to have an attorney, and all that stuff that goes along with charging somebody with a criminal offense in the state of Florida.
Basically, right now, we just put a lien on the property, correct?
Yes.
Make it a civil infraction,
Yes, civil infraction.
or guilty of a civil infraction.
And if we have to take it to, if they ignore the notice, I mean, I know we got, if they ignore the notice and it's just a civil infraction, then we don't have to pay for their attorney fees, right? If we have to go to courts to get
Yeah, because
a
you're
court
only,
order
you're only guaranteed an attorney in the Constitution for criminal.
for criminal.
So
Okay.
anything civil we would.
I just wanna make sure. Commissioners, how does everyone feel about that? With taking, if we were
It's kind of what we have with our whole code,
gonna strike through?
this process.
Commissioner DeVito?
Yes, it seems to me that, again, this violations provision is very generic. I think to avoid confusion, we should use our current violation provision. Because I'm assuming they comply with Florida law and they do, we've already enacted that. Can we do that, Bobby?
Violate of what?
Use our current violation provisions. Don't we already have the provisions about violation of our codes?
Yeah, we have that class of fines. Usually it'd be punishable as
Assigned to class?
a, yeah.
Well,
Or
that's,
it's something that could be done when you set the, I mean, the violations can be set in there, in this code itself.
I mean, we have a situation right now where we reached out to somebody and we're not getting, and it's gonna, we don't have anything in our current codes to allow us to do what needs to be done, so we have to go to the courts,
Yes.
correct?
Well, we have something in our code, but I don't think
Yeah,
it's legal.
it's legal,
Yeah.
yes. So,
what kind of violation is that?
It's a code violation in our code and I think it's from like 1957, allows for us to go in and just fix the problem.
Right.
And I wouldn't ever advise for the city to enter anybody's property without a court order designating it as a public nuisance. So we have a piece of property in town that is causing some problems that probably would be labeled as a public nuisance.
Right.
But our code allows that if our public health official determines it a public health emergency, that we can go in and rectify the situation without permission of the landowner.
But I was gonna ask you about that, because I have a picture of something. So you're saying our code is out of date and on that provision?
Yes.
I wondered about that. Okay, so, but, I mean, essentially what I'm saying is whatever provisions we have for violations in our existing ordinances, minus any outdated unconstitutional ones, shouldn't we use what we have?
Yeah, if we wanted to, but I think that we should make it specific what the violation is gonna be in this code.
Okay.
to put it into here, to
Yes.
incorporate it into here.
Yes.
So we need to,
Yes.
so when we get to that point, if we ever get to that point, we need to make sure we've looked at that too, to see if that's,
Yes.
okay.
Or if there's something in our code that we're fine with, it, we can just reference that the violation will be punishable as stated in whatever chapter or section it is in our code, and we can just reference it. The only problem with that is when you reference stuff, like we ran into with some of the fee stuff, when you reference stuff in different ordinances, by you passing ordinances and amending stuff, you're amending things and repealing ordinances that affect other ordinances.
You want to just add the language in here?
That's what I would recommend. So then if it ever needed to be changed, or if the city grew and we were like, we can afford to, we need to start making this a crime, we could just go in and change it here, and it would only affect this ordinance rather than having to go in and change something else that may affect another thing that we don't want to be
Okay.
criminal.
So
Okay.
add the fine classifications to this.
Yeah, I would, yes.
Okay. Everybody good with that?
Yeah.
Okay.
Violation penalties. Any person who shall violate a provision of this code or fail to comply therewith or with any of the requirements thereof shall be prosecuted within the limits provided by state and local laws. Each day that a violation continues after due notice has been served, shall be deemed a separate offense.
But don't we already have this?
We just have a running, Pam, we just have a running fine, right? We don't, it says each day that a violation continues after due notice has been served shall be deemed a separate offense. We just have one offense that the fine just runs until it's corrected.
Yes, the code enforcement board, but you can, if somebody has a flag that's out that's a code violation, you can go and cite them every day.
What about like overgrown lawn?
No, we're going along with it, we go to the code enforcement board and then the fine will just accrue until it's in compliance.
So you just cite them once and it runs,
Right.
but a sign you're saying is different.
Well, I just use a sign as an example.
So,
Why
they-
wouldn't the sign just run, or other,
yeah, why would,
all of them just run?
They can. But if it's an intermittent thing, you know, if you had somebody that put out a sign today and took it down.
Oh, I see.
You know, then if they put it back out tomorrow, it'd be a new violation, and you could cite them for every day.
Could
Or
you,
each offense would be each day would be a different offense.
Could you do that like with an overgrown yard?
I wouldn't, no.
So that's what this is saying. Each day the violation continues after due notice has been served shall be deemed a separate offense.
I mean, I think that each day that you were in violation could be a separate offense if we wanted to do that, even with the yard. Because you violated the code and you violated the code, and that's how it's stated in there. I don't.
Even though we've given them
necessarily-
10 days to rectify it.
Well, yeah, if you give them 10 days to fix it, then no, you couldn't. Well, once they got outside.
if they haven't fixed it as of that 10th day, that 11th day, then
Could
you
be
could
in
cite
there.
them again for
Yes.
that same offense.
Okay, but to me, this is very confusing because then wouldn't this turn into multiple appeal cases?
It would turn into a mess. It sounds like you'd have 30 violations because it went for a month. Maybe we can strike that sentence.
This is not what we have, and I don't understand how we would administer it. I mean, unless the only time this would be helpful is if we had penalties for, increasing penalties for repeat offenses. But I don't know, I mean, that's why I'm saying I think we should use what we already have and not just generic language, because I can't imagine how we would manage 10, 20, 30 separate cases for basically the same situation.
And I think that that's what we're doing here is we're going through this. If what we have is working, then we need to incorporate this in here. We don't necessarily have to
Yes.
take that, adopt that. Is that correct, Carl, Bonnie?
Yeah, I think that instead, take all that general language out and put in any person who shall violate a provision of this code, and that's what the penalty's gonna be instead of state or local laws.
Okay.
Let me ask this, posing, well, it's not posing, it doesn't happen. When we bring in, and the code enforcement bring an individual in, and they had a violation, and we canceled it. How much time do we get them to rectify some of the situation? Instead of just let them alone and just let it go back up again? I think it's on a runoff, I think you know the property I'm talking about.
New owner stepped in, correct, and said he was gonna do one cleaning up?
No, the owner, yeah, well, he got it on tax deed, I think he did. I
I
think
think he
that,
bought it.
huh?
I think he bought that one,
Yeah,
he purchased that lately, but, I have that in my pile of things to do.
yeah.
Hate to use that term publicly. I'm going to cite him for the condition of that property. It's overgrown again
Okay.
and non-compliance.
But Commissioner Banks, what you're saying is we forgave,
Yeah.
we forgave,
We
and
forgave.
then with a promise from him that he was gonna be a good steward.
Right.
He's now not a good steward. I guess we can't go back in, and what you're saying is, I'm not gonna certainly don't want to put words in your mouth. Are you asking,
Yeah.
can we go back and bring that back forward, or do we have to start
I
over?
think we're gonna start new the way.
We have to
We have
start
to start
over,
over.
okay,
He's a new owner and that fine and lien had been resolved.
okay.
And he's a new owner, so it starts as a new case. It starts from the beginning.
I just wanna make sure that you're.
What about the one on Chestnut?
Okay.
That one's
That's different. But
Chestnut, we have 2 fines currently running on that property, daily fines.
Right, and could I say something about this situation on Randolph Street that Commissioner Banks was talking about? And I might have heard Commissioner Banks say this, but that is a lesson for us in forgiving these fines
Yes.
with no conditions, because, he wrote a really heart-rending letter, but, as we all know, words are cheap, and the proof is in the pudding. And we probably didn't even investigate him and what kind of property owner he was before. So, maybe before we start waiving these fines, we should make sure that, we could pen them instead. Because basically, I think we've been taken advantage of again. So,
And Chestnut is an area that I would like to fund every single day. if we could, if we had the ability to do so. So,
Well, I wonder if we, Bobby will come back, we could say each day that a violation continues after due notice has been served may be deemed a separate offense, as opposed to shall be. Gives us the option
Or
of.
do
I
we
like
want
that.
every other?
I like that.
Maybe.
And I'm not really sure what the advantages of citing day after day if the same one is running, the first one is running still.
Because they're still getting,
Sometimes jurisdictions use a citation process, where they write like a traffic ticket, and if they write a violation for, not having the electrical box where it's supposed to be, say, and they don't move it by tomorrow, then it's a separate offense. And they can come back and write another citation the next day.
What's the advantage if instead that first citation just keeps accruing a fine every day? What's the difference?
I don't think there's any advantage to really writing a citation every day, other than that sometimes they're tiered, the first offense $50, the second one.
Oh, I see, yeah. And that is,
$150 in a mandatory court appearance.
and that's something that maybe we could look at. We did that with our sound ordinance. It's tiered.
Yeah, the citation,
Yep,
yeah.
we tiered that, so that might be,
Right.
anything to get people to react.
it's about, we're still on 109.4.
But that's what I said, the separate offense is only really useful if you have tiered penalties. And I don't know that we have that for our code violation.
We now have it for noise.
We have it for
I
noise.
mean,
Right, but I'm talking about our building.
Do we
Right.
feel that that's a viable solution, Dan, to maybe some of our code violators out there, that if we did have a tiered, violation, where every day it's 25, now it's 50, now it's 75, 100, actually,
You can fine someone on a first offense up to $250 per day.
per day?
That's up to the discretion of the code enforcement board usually. And then if it's a repeat violation, it can be $500 per day.
Okay,
So if somebody has high weeds and vegetation and they clear it up, and then 2 months from now it's grown back up, I could take them back to the code enforcement board, and the code enforcement board could fine them $500 per day.
We have that ability as it's currently written.
Yes.
So how do we need to wordsmith 109.4? You said take out provided by state and local laws.
Well, I think that if we just take out any person who, or don't take out, have any person who shall violate a provision of this code shall be punished as follows. There should be subject to the following fines, and if you want it to be tiered, that's where you lay out the tiered system. If you want it to be just one flat fee, I don't think you need to have them there each day. The problem is, if you take it out, then you don't have the ability to do that, but if you leave it in there, it would be up to the discretion of the code enforcement officer to, if they need to decide on it every day. I don't know if that would improve compliance, because some of our code liens are like $100-something thousand, so I don't think it would necessarily improve.
Yeah, we got rid of all of those.
To assign them every single day, but
So what do we do with that last sentence? Strike it? Or put it, shall, maybe deemed a separate offense?
Okay.
Put shall with may?
yeah, you could.
Yes, Commissioner DeVito?
Okay. I think this is a very worthy undertaking. This is something that we probably need, and I think that's a discussion that we should have. I don't think we're ever going to get this done if we draft it in a commission meeting. Our job is to set the policy, then staff is supposed to draft the language to put our policy issues into effect. It's very unusual and it's not time effective to have the drafting done in the commission meeting.
No, but I brought this to you to adopt, and you said, no, we need to go through this.
So we're not,
So-
yeah, so we're not going through this in a commission meeting. This is a workshop for us to
Or-
work through it.
You don't even draft in a workshop. Yes, we said we need to go through it, but I think the objective is to, as opposed to reading it word for word, the objective is to find the policy issues that we either want to have or not want to have, And it's the proper drafting should be done in the proper drafting situation, not necessarily in the workshop. We are nowhere near where we should be, so to me, I think we did this with something else. We went through and said, does anyone have any questions about a specific page? I think this is very important because we have some very difficult situations in town.
And that's why, I mean, before we go any further, I think that's why Charles is trying to go through this one paragraph by paragraph, because this
Well,
is,
can I say something?
Yes, sir.
Here's my problem with that theory. If we were to do that, then Charles and I would be drafting something, and then we come and say, hey, we should adopt this, and then Charles and I have drafted, and now you have adopted without any input from y'all, something that goes into effect and affects the city when y'all are the ones that are elected. When we have to do this, Charles and I just go back and forth, and then we bring something together and we bring it to you, and if it's changed with substantial changes, then we're gonna go back to another first reading, and that's gonna cost the city however much it costs to do it. It's almost impossible for us to draft something for y'all without input from the commission. We've tried to do it in the past, and we run into problems because we're not able to contact y'all and say, hey, how do you feel about this? Obviously, we can come with recommendations, and if you have recommendations and I don't think they're legal or something like that, I think this is the best way for us to save time and the best use of time to draft something so we get it right the first time when we bring it back for first reading. Everybody's on the same page, the changes were made, and here it is.
that was my understanding, the whole reason that we were going through this, is so that we could give some directive, we could all sit here and talk about what we have some concerns about, and, as we go forward. Commissioner DeVito, since we've arrived here,
Yes.
you have all made it very clear that you are not in agreement with this, but I want to ask the other commissioners, are we all in agreement with going forward and going the way we've been going so far?
I think we have to.
I think we have to, because 9 times out of 10, if we don't and they bring it back, he's right.
And Charles,
We're going
Excuse
through it
me.
anyway. Yeah.
that last sentence in 109.4, where it has been served shall, if you can change shall to may,
May.
and you have the choice, yes or no.
Okay, so let's move forward,
Okay.
please.
So let's.
Abatement of violation. The imposition of the penalties herein prescribed shall not preclude the legal officer of the jurisdiction from instituting appropriate action to restrain, correct, or abate a violation, or to prevent illegal occupancy of a building, structure, or premises, or to stop an illegal act, conduct, business, or utilization of the building, structure, or premises. Seems pretty straightforward.
Okay. Everyone in agreement with that?
Yep.
Okay.
Section 110, stop work order. Where the code official finds any work regulated by this code being performed in a manner contrary to the provisions of this code or in a dangerous or unsafe manner, the code official is authorized to issue a stop work order. The stop work order shall be in writing and shall be given to the owner of the property, to the owner's authorized agent, or to the person performing the work. Upon issuance of a stop work order, the cited work shall immediately cease. The stop work order shall state the reason for the order and the conditions under which the cited work is authorized to resume. Where an emergency exists, the code official shall not be required to give a written notice prior to stopping the work. Any person who shall continue any work after having been served with a stop work order, except such work as that person is directed to perform to remove a violation or unsafe condition, shall be subject to fines established by the authority having jurisdiction.
Okay?
Anybody have any
Pretty straightforward.
questions? Okay.
Unsafe structures and equipment. When a structure or equipment is found to be, by the code official, to be unsafe, or when a structure is found unfit for human occupancy or is found unlawful, such structure shall be condemned pursuant to the provisions of this code. Unsafe structure. An unsafe structure is one that is found to be dangerous to the life, health, property, or safety of the public or the occupants of the structure by not providing minimum safeguards to protect or warn occupants in the event of fire, or because such structure contains unsafe equipment, or is so damaged, decayed, dilapidated, structurally unsafe, or of such faulty construction or unstable foundation that partial or complete collapse is possible.
Um,
That's- Go ahead.
I just want to ask a question on this. Pam, do you have to go to the county as far as to, deem one of those a structure unsafe.
Yes, I call the building official, and he comes out and inspects it, and then, puts a placard on it that says it's unsafe and condemned, unfit for human habitation.
Okay.
Unsafe equipment. Unsafe equipment includes any boiler, heating equipment, elevator, moving stairway, electrical wiring or device, flammable liquid containers or other equipment on the premises or within the structure that is in such disrepair or condition that such equipment is a hazard to life, health, property, or safety of the public or occupants of the premises or structure. Structure unfit for human occupancy. A structure is unfit for human occupancy whenever the code official finds that such structure is unsafe, unlawful, or because of the degree to which the structure is in disrepair or lacks maintenance, is unsanitary, vermin or rat infested, contains filth and contamination, or lacks ventilation, illumination, sanitary or heating facilities, or other essential equipment required by this code, or because the location of the structure constitutes a hazard to the occupants or the structure or to the public.
Does anybody have any questions on that? Pam, do we have anything in our current code that, deals with that? That you're aware
I didn't bring a copy of the building code with me, but I think we do have something that says unsafe.
of? Okay.
But then again, the building official comes and inspects it and deems it
Okay.
unsafe.
At what point does the health department, would the health department come in?
If it's a health-related thing, like breeding mosquitoes or,
Okay.
um,
Filth, contamination?
you know, septic tanks that aren't
Okay.
functioning properly.
Yes, sir.
By Bay Street. Or the old Church of God in Christ.
Yes, I know.
Can you speak to them?
Yeah, how would we classify that? Shouldn't that building be condemned? The county should come out and put a condemned sign on there and try to get the occupants, what's in there, out of there, or somebody get hurt? Or-
I can contact the building official and have him condemn it, ask him to consider it, to condemn it, yes.
Yeah, because we got somebody living on that
Yes,
porch, I
yeah,
think.
they living on the porch inside there too.
Or are they inside now?
Yeah, I think the place might catch on fire on them, and that'll be a real hazard. Cause a house, you know, is kind of right there by. So,
Okay.
something wrong with that, so we need to act on that as quick as possible.
I think that one has a clouded deed, doesn't it, or
It does.
it was sold by people who weren't able to sell it or something?
The heirs didn't probate the property, and they sold it to a holding company, and then they sold it again, and then took it back, because they realized they weren't supposed to sell it, but there is a property, maintenance company that takes care of it.
Because we cited that property already, right, multiple times.
I'm gonna send out another notice tomorrow.
Let's have the building official take a look at it.
I wrote that down.
Okay, unlawful structure. An unlawful structure is one found in whole or in part to be occupied by more persons than permitted under this code, or was erected, altered, or occupied contrary to law. Dangerous structure or premises. For the purpose of this code, any structure or premises that has any or all of the conditions or defects described as follows shall be considered to be dangerous. Any door, aisle, passageway, stairway, exit, or other means of egress that does not conform to the approved building or fire code of the jurisdiction as related to the requirements for existing buildings. The walking surface of any aisle, passageway, stairway, exit, or other means of egress is so warped, worn, loose, torn, or otherwise unsafe as to not provide safe and adequate means of egress. Any portion of a building, structure, or appurtenance that has been damaged by fire, earthquake, wind, flood, deterioration, neglect, abandonment, vandalism, or by any other cause to such an extent that it is likely to be partially or completely collapse or become detached or dislodged. Any portion of a building or any member, appurtenance, or ornamentation of the exterior thereof that is not of sufficient strength or stability, or is not so anchored, attached, or fastened in place so as to be capable of resisting natural or artificial loads of 1 1/2 the original design value. The building or structure, or part of the building or structure, because of dilapidation, deterioration, decay, faulty construction, the removal or removement or movement of some portion of the ground necessary for the support or for any other reason is likely to partially or completely collapse, or some portion of the foundation or underpinning of the building or structure is likely to fail or give way. The building or structure or any portion thereof is clearly unsafe for its use and occupancy. The building or structure is neglected, damaged, dilapidated, unsecured, or abandoned so as to become an attractive nuisance to children who might play in the building or structure to their danger, becomes a harbor for vagrants, criminals, or immoral persons, or enables persons to resort to the building or structure for committing a nuisance or an unlawful act. Any building or structure that has been constructed, exists, or is maintained in violation of any specific requirement or prohibition applicable to such building or structure provided by the approved building or fire code of the jurisdiction, or of any law or ordinance to such an extent as to present either a substantial risk of fire, building collapse, or any other threat to life and safety. A building or structure used or intended to be used for dwelling purposes because of inadequate maintenance, dilapidation, decay, damage, faulty construction or arrangement, inadequate light, ventilation, mechanical or plumbing system, or otherwise is determined by the code official to be unsanitary, unfit for human habitation, or in such a condition that is likely to cause sickness or disease. Any building or structure, because of a lack of sufficient or proper fire resistance related construction, fire protection systems, electrical system, fuel connections, mechanical systems, plumbing system, or other cause, is determined by the code official to be a threat to life or health. Any portion of a building remains on a site after the demolition or destruction of the building or structure, or whenever any building or structure is abandoned, so as to constitute such building or portion thereof as an attractive nuisance or hazard to the public.
Okay, do we want to, that's a
No,
lot,
that's
that's
a
a lot, that's a lot, take a drink. Does anybody have any comments on this?
I think it's
What we got?
pretty specific as to.
Comprehensive.
Comprehensive.
Very comprehensive,
Right.
yeah. Again, in here, it has code official, I wonder if that's one of the places that we want to put appropriate code official.
Yeah,
Yeah, we'll do a research.
and for each one of these, I could name a place right now.
As we were going through, I'm like, oh,
Yeah, I know.
okay.
Closing of vacant structures. If the structure is vacant and unfit for human habitation and occupancy, and is not in danger of structural collapse, the code official is authorized to post a placard of condemnation on the premises and order the structure closed up as to not be an attractive nuisance. Upon failure of the owner or owner's authorized agent to close up the premises within the time specified in the order, the code official shall cause the premises to be closed and secured through any available public agency or by contract or arrangement by private persons, and the cost thereof shall be charged against the real estate upon which the structure is located, and shall be a lien upon such real estate, and shall be collected by any other legal resource.
Okay.
Does that touch on the abatement issue we talked about?
I would think that
You
would,
cannot abate a property. This is saying we could board up a property. 111.2. The code official shall cause the premises to be closed and secured through any available public agency or contract arrangement by private persons. And then we
I
charge-
guess if it's vacant, it doesn't say, it says vacant and unfit, so it would have to have been determined unfit, not just vacant.
Well, it's my understanding that you have to have the permission of the property owner to do that. Didn't we run into that with the Newman Lodge? I mean, to me, this is something that Bobby would review for legality. And it sounds like it doesn't really fit with what I've been told is Florida law.
He can get a court order.
You'll look that one up.
He has to go to the court though to get a court order for abatement. Is that correct, Bobby?
Yes.
Right, so what I'm saying is, I don't think this language fits Florida law, so that's something that Bobby would have to do something with.
Okay, we'll look that one up. Authority to disconnect service utilities. The code official shall have the authority to authorize disconnection of utility service to the building, structure, or system regulated by this code and reference codes and standards set forth in section 102.8 in case of emergency when necessary to eliminate an immediate hazard to life or property or where such utility connection has been made without approval. The code official shall notify the serving utility and, whenever possible, the owner or owner's authorized agent and occupant of the building, structure, or service system of the decision to disconnect prior to taking such action. If not notified prior to disconnection, the owner's authorized agent or occupant of the building, structure, or service system shall be notified in writing as soon as practical thereafter. That was pretty straightforward.
Well, do we have the authority to disconnect people's utilities?
Yeah, usually that's the remedy if somebody is building without a building permit or does some type of improvement.
We just turn off the power, basically, or the water, or the.
I mean, we can do it if they don't pay too, so.
Yeah. Okay, record, the code official shall cause a report to be filed on unsafe condition. The report shall state the occupancy of the structure and the nature of the unsafe condition. Notice, whenever the code official determines that there has been a violation of this code or has grounds to believe that a violation has occurred, notice shall be given in the manner prescribed in sections 111.4.1 and 111.4.2 to the owner or the owner's authorized agent for the violation as specified in this code. Notices for condemnation procedures shall comply with this section. Form, such notice shall be in accordance with all the following: be in writing, include a description of the real estate sufficient for identification, include a statement of the violation or violations and why the notice is being issued, include a correction order allowing a reasonable time to make the repairs and improvements required to bring the dwelling unit or structure into compliance with the provisions of this code. Inform the property owner or owner's authorized agent of the right to appeal. Include a statement of the right to file a lien in accordance with section 109.3. That was pretty straightforward. Method of service. Such notice shall be deemed to be properly served where a copy thereof is served in accordance with one of the following methods. A copy is delivered personally. A copy is sent by certified or registered mail addressed to the owner at the last known address with a return receipt requested. A copy is delivered in any other manner as prescribed by local law. If the certified or registered letter is returned showing the letter was not delivered, a copy thereof shall be posted in a conspicuous place in or about the structure affected by such notice. Service of such notice in the foregoing manner upon the owner's agent or upon the person responsible for the structure shall constitute service of notice upon the owner. And that's what we have now, right?
Yes.
But we can have that legally served, correct? You could have notice properly served in person by a law enforcement or,
Yeah.
okay. That's-
Authorized
Authorized.
tampering. Signs, tags, or seals posted or affixed by the code official shall not be mutilated, destroyed, or tampered with, or removed without an authorization from the code official. Transfer of ownership. It shall be unlawful for the owner of any dwelling unit or structure who has received a compliance order or upon whom a notice of violation has been served to sell, transfer, mortgage, lease, or otherwise dispose of such dwelling unit or structure to another until the provisions of the compliance order or notice of violation has been complied with, or until such owner or the owner's authorized agent shall first furnish the grantee, transferee, mortgagee, or leasee a true copy of any compliance order or notice of violation issued by the code official, and shall furnish to the code official a signed, notarized statement from the grantee, transferee, mortgagee, or leasee, acknowledging the receipt of such compliance order or notice of violation and fully accepting the responsibility without condition for making the corrections or repairs required by such compliance order or notice of violation. That's not been happening. That's one of our challenges, properties are selling.
Just have that out.
So this is saying that would be a requirement. What happens if they sell a property, Bobby, and they didn't tell them they paid to get, there are limitations.
Right, I mean, it depends, if they quit
Well,
claim.
short quit claims and all that seems to be circumventing the title search.
I mean, if you quit claim deed it, obviously the lien runs with the land, not the owner, so if they were to transfer it, that person would take the property subject to. I'll look into that, I don't know if we can restrict somebody's ability to sell property, especially with the,
Right.
I don't know if we have that power.
Well, that was my question.
Okay, so
And
now
then-
we'll look at that.
If someone quit claims, the person who takes the property by quit claim, that they take it at their own risk. We're not responsible for their failure to have notice.
Ignorance of the law is no excuse.
back to, if we go back to unauthorized tampering, it just says they should not do that. It doesn't say what happens if they do that. Do we want to add anything in there that should be subject to a fine, or, it just says,
We'll never
shall not be mutilated, destroyed, or tampered with. I'm just bringing that up, for discussion. There's just nothing there, it just kind of just, whoop,
Yeah, I guess there's no
Don't
way to
do
know
it.
who did it. You just,
don't do it.
you notice
Okay.
that it's gone.
Doesn't,
Isn't there a general violation provision somewhere in here?
We're gonna have
Go to it, we'll get
have
to
a
it.
lien on
No, she's saying about messing with the tags or
Somebody
if
removes
they
seals.
the-
tag it, if they tag it.
Sign.
I think, I just wrote in their penalties, somewhere I think there's a general violation provision.
Okay, I'll put in there too. Go ahead.
Placarding. Upon failure of the owner's authorized agent, or person responsible to comply with the notice provision within the time given, the code official shall post on the premises or on the defective equipment a placard bearing the word condemned, and a statement of the penalties provided for occupying the premises, operating the equipment, or removing the placard. Such notice shall be posted in a conspicuous place in or about the structure affected by such notice. The notice pertains to the equipment. It shall be placed on the condemned equipment. Placard removal. Code officials shall remove the condemnation placard whenever the defect or defects upon which the condemnation placarding action were based have been eliminated. Any person who defaces or removes a condemnation placard without the approval of the code official shall be subject to the penalties provided by this code.
I guess that would be kind of
Yeah, what we were just talking
what
about.
we were just talking about.
Right. But what?
It doesn't say what the penalties are, but we haven't even gotten to the penalties yet. Prohibited occupancy. Any occupied structure condemned and placarded by the code official shall be vacated as ordered by the code official. Any person who shall occupy a placarded premises or shall operate placarded equipment, any owner or owner's authorized agent who shall let anyone occupy a placarded premises or operate placarded equipment shall be liable for the penalties provided by this code. Restoration or abatement. The structure or equipment determined to be unsafe by the code official is permitted to be restored to a safe condition. The owner's authorized agent, operator, or occupant of a structure, premises, or equipment deemed unsafe by the code official shall abate or cause to be abated or corrected such unsafe conditions either by repair, rehabilitation, demolition, or other approved corrective action. To the extent that repairs, alterations, or additions are made, or a change of occupancy occurs during the restoration of the structure, such repairs, alterations, additions, or change of occupancy shall comply with the requirements of the International Existing Building Code. That's, seems pretty straightforward.
I mean, I would just put the requirements of the Florida building code.
Yeah, I think we need to take that thing.
We'll say
Yeah,
Florida
that's-
building code. Imminent, emergency measures, imminent danger. When, in the opinion of the code official, there is imminent danger of failure or collapse of a building or structure that endangers life, or when any structure or part of a structure has fallen and life is endangered by the occupation of the structure, or when there is an actual or potential danger to the building occupants or those in proximity to any structure because of explosives, explosive fumes or vapors, or the presence of toxic fumes, gases, or materials, or operation of defective or dangerous equipment, the code official is hereby authorized and empowered to order and require the occupants to vacate the premises forthwith. The code official shall cause to be posted at each entrance of such structure a notice reading the following: this structure is unsafe and its occupancy has been prohibited by the code official. It shall be unlawful for any person to enter such structure except for the purpose of securing the structure, making the required repairs, removing the hazardous condition, or demolishing the same. Temporary safeguards. Notwithstanding other provisions of this code, whenever, in the opinion of the code official, there is imminent danger due to an unsafe condition, the code official shall order the necessary work to be done, including the boarding up of openings, to render such structure temporarily safe, whether or not the legal procedure therein described has been instituted, and shall cause such other action to be taken as the code official deems necessary to meet such emergency. And that's something you're going to look into, Bobby, as well. 112.2. Closing streets. When necessary for public safety, the code official shall temporarily close structures and enclose or order the authority having jurisdiction to close sidewalks, streets, public ways, and places adjacent to unsafe structures and prohibit the same from being utilized.
Giving her, I mean, we're giving the code official an awful lot of,
This will be the building official, it looks like the building's gonna
Gonna
fall,
fall,
he
it
can
would
shut
be-
the street down, give him the
Okay.
authority to. I had that in, I worked in Eustis, the building burned, and the big face just fell over into the street. They put the fire out, and then a few hours later, the whole front of the building fell over into the street.
It's my understanding this is always done when there's a severe danger.
Yeah. Emergency repairs. For the purpose of this section, the code official shall employ the necessary labor and materials to perform the required work as expeditiously as possible. That's part of what Bobby's looking at. Can we do that? Costs incurred in the performance of emergency work shall be paid by the jurisdiction. The legal counsel of the jurisdiction shall institute appropriate action against the owner of the premises or owner's authorized agent where the unsafe structure is or was located for the recovery of such costs. Any person ordered to take emergency measures shall comply with such order forthwith. Any affected person shall thereafter, upon petition directed to the appeals board, be afforded a hearing as described in this code.
and again, that would be our code enforcement board, correct?
So Bobby, you need to look into those emergency actions if we can just do stuff without the permission of the property owner.
So again, when it comes to demolition, don't we already have provisions on demolition?
What was the question?
That she
Don't
said,
we already have provisions on demolition?
We do.
We have provisions on demolition?
We can just go in and demolish a building,
No,
No, we have to take it to court.
have to get to court.
but it just, I mean, looking at this,
Let's see.
I think we need to use what we have and comply with Florida law. This is very generic, and I think there's parts in there that don't comply with Florida law.
okay, why don't you go ahead and read it, we haven't read it yet?
Demolition. The code official shall order the owner or owner's authorized agent of any premises upon which located any structure which in the code official or owner's authorized agent judgment after review is so deteriorated and dilapidated, or has become so out of repair as to be dangerous, unsafe, insanitary, or otherwise unfit for human habitation or occupancy, and such that it is unreasonable to repair the structure, to demolish or remove such structure, or if such structure is capable of being made safe by repairs, to repair and make safe and sanitary, or to board up and hold for future repair, or to demolish and remove at the owner's option, or where there has been a cessation of normal construction of any structure for a period of more than 2 years. Code official shall order the owner or owner's authorized agent to demolish and remove such structure or board up until further repair. Boarding the building up for future repair shall not extend beyond 1 year unless approved by the building official.
So Pam, you're saying that as ours reads, it has to go, it would have to have a court order in order to do that,
To
correct?
demolish it?
Yes. Okay.
So,
Probably just said that's Florida law. We can't just not.
Yeah, our code official cannot order somebody to demolish.
To demolish
or remove
their,
the
to
building.
their, nor can we go in and demolish it?
No.
Okay, no. Well, I'm asking a question, and that's,
No.
okay? I just want to make for clarity, so that it's clear. Okay, so go ahead.
So do we want to
Excuse
strike
me.
the whole thing?
What about this 1 year?
and the bulbs up,
And then what?
cause we got some that had bulbs on them for years.
Years, right.
They've been preparing for that next hurricane from the last hurricane.
Yeah,
I mean, I think
Wanna
this thing would say
strike
that
1 year?
if it was for more than 1 year, then the code official could order them to demolish it, which can.
They can't do that.
Okay, this is an example of, this is not what we're talking about here. The boarding up in this paragraph has to do with the code official ordering it. It's not speaking to the other situation we have where people are just boarding their places up. And that's something I have a question about. Is there anything here in this proposed ordinance that would apply to that situation? That an owner boarding their own property is not what they're talking about in here. That's separate.
But it does say here that capable of being made, or to board up and hold for future repair, or to demolish. So, I mean, we've got some people that have boarded up because the windows are out, and it needs to be repaired. So
For
That's
years,
two different things.
Right, but
Yeah.
I'm saying it's two different things. This is
this is,
an order. It's a different situation that I think we need to address
I
in
think
whatever
we
part of the
already have
ordinance
something
would
in
apply.
place in order to demolish something, right? So what we need to do is take, it sounds like we need to take this section
Out.
Just
and,
strike this.
and put the section that we normally would have.
and
what
just
we-
maybe review our section that we have to, that we're all in agreement with it.
And make sure we're all in
Yeah.
agreement.
That's what I was thinking, was
Yeah.
specifically when you're looking at 1 year, 1 year.
And that's what Commissioner DeVito stated when, you know, that,
All right, let's keep going.
notices and orders.
Leave that mark. Okay, we'll look at what our rules are.
Yeah, that's what our rules
Yeah.
are.
So we'll go to chapter, so we're gonna take, questions on chapter 1 before we move on?
Well, do you want to go, you would take in all of this out, salvage
Yeah,
materials?
Yeah, it's all the.
Everything?
Yeah, it's just saying if we
Okay.
demolish it, we
I
can
just wanna
salvage
make sure.
material.
Okay. So yeah, this, before we go into chapter 2, did we have, Commissioners, do we have any other discussion on this for right now?
No.
Okay, if not, I'm gonna open it up for public comment.
Can I wait for Charles to come back?
Do you need him to?
Oh.
He can, he's quick.
Okay. Well, I don't know if this is a Charles question.
We can wait, Diane, if you want to, we'll be happy, you can wait if you'd like for him to, or wait till they get
Actually,
back.
you know, it'd be a good time to give us all maybe 5
We can
minutes.
all,
Okay.
5 minute
Take a
break,
break.
okay, I'm gonna
Take a
recess
break.
for 5 minutes, how's that?
Okay.
And then we'll take public comments, okay.
Steve.
Yes, we need to talk about it.
yeah, I need to.
We gotta figure out how we're gonna get, how we're gonna recovery. We're gonna open it up for public comment. If you'll come forward, state your name and your address.
Same record serial number. Okay. Diane Sykes, 304 Chestnut Street. I was gonna ask about which communities did Charles investigate, but I heard you say earlier it was Winter Haven's policy that we're reviewing here?
No, I just had it as reference, like what they, if we want to strike something, what they did with the same provision.
So where did this particular one come from that we're
This is the
modifying?
international minimum maintenance standards. It's a international standard that you could, a community, like, for example, Bradenton just adopted it as is. Some counties have adopted it. Winter Haven, which is one that I found that had tweaked it a little bit.
Okay, I just wondered how it compared to our rural Crescent City and the demographics and diversity and all of that. And whether the comparisons was with gated communities or planned development communities like Palm Coast, or was it rural development, rural communities like ours that it is?
It's an international, it's just basically
It's just
a
a
standard, a
standard
minimum
we
maintenance
got now.
standard, regardless of your, you know.
Okay, who has the authority to direct Pam to inspect properties?
I do,
Okay, only you? It's only the city manager has the authority?
yes.
Okay, okay, that was pretty much, as far as questions, and as far as I guess, because it says qualified, it talks repeatedly in this standard about qualified individuals. I don't know what qualifies anybody here in this room to make some of the decisions that we're saying we have the authority to make. We should state on the notice, we're talking about the notice in section 111.5. I think the notice should state that it cannot be removed except by code official, because we talked about putting this notice up, and that it shouldn't be removed except by a code official. Maybe if we put it on the notice to that effect, maybe people didn't remove them. Maybe they would anyway. But that was all I had on chapter 1. So it was just using Winter Haven as an example. Okay.
Thank you very much. Do we have any other public comment? Anything you want to add? Anything that
I'd like
you have a concern?
answer Diane's questions there. The condemned stickers that the building department puts on buildings do say they can't be removed except by, an authorized person. And, what was your other question?
Who has the authority to direct you?
No,
Well, who has authority, who directs Pam to inspect properties and what qualifies
so
them to do
people
so?
do take, yeah, people do take them, but they're not supposed to. You know, they take them off the buildings sometimes.
I think the question that she's asking was, who gives you,
Who has the authority to
Right.
tell you what to do? And it's only the city manager.
Charles tells me what to do.
Okay,
All
all right.
the
So no other commissioner can tell you to go do
Okay,
something?
correct.
Okay.
Just to clarify there, it was my understanding that under our code, if Pam sees a violation,
She's self-directed.
yes, she's.
Yeah,
Yeah.
she's
is
self-directed.
authorized. Now, we had a policy in the past, I think, way back, or whatever, that said, the code officer wasn't to write up anyone unless there was an independent complaint, but the actual ordinance allows her to act on what she sees, right?
Yes.
Okay, we just want to make sure that's
And we're all able to ask her about a property. We can ask her about a property, but as far as directing her on a property, we're supposed to go through Charles if we have a concern, or if a resident has brought a concern to us, and then Charles is to direct Pam, just like he's supposed to direct all of his staff.
And
Not
residents
us.
can reach out directly to her and
Yeah.
complain. And then, if they're willing to be the complainant, she can act on it, but we can't have anonymous complaints.
Right, because now there can't be anonymous complaints.
There
Is that
are no
correct?
such thing as anonymous complaints anymore. I like that. If you have balls to complain about it.
Okay. Yes, sir, if you'll state your name and address.
335 Steve Johnson. It seems to be extremely involved, like the present codes and this overlaying it. I mean, there could be discussions for weeks. You know, but I see things, like I'll see things, and it's, Pam can appoint a deputy. Pam can render interpretations. I mean, these are kind of like red flag things. No liability, criminal, civil, or personal. You know, if she appoints a deputy, is that person, can they render interpretations? Do they have no liability? You know, I mean, I'm just saying, if discussion can go on for a week on one paragraph.
We struck the
It's
part.
just-
We're kind of seeing that.
It's
Instruct
kind
the
of,
deputy.
it's, we're already through chapter 1, but, you know, we could have a discussion about that for the next 2 hours.
And we said that too, in starting this, is that this, we're not gonna accomplish everything today.
Right.
We might just touch on some things and bring it back and have another workshop, you know, as some of this percolates with us too, and we've
Right.
discussed it, we've heard what other people have said. So it's not something that we're gonna bring up. Bobby's not preparing an ordinance right now, correct, Bobby? So,
Not yet.
Commissioner DeVito, you had something to say?
Yeah, well, I think I'm right about this, but I want to ask it as a question. It's my understanding that the language, and this is, Steve, this is for responding to what you've asked about the issue of the code. This ordinance would give the code official the ability to interpret and make determinations. It's my understanding that that is what a code enforcement officer does.
She does it every day. yeah.
Right, that language simply says what a code enforcement officer does. That is practically what happens. So a lot of this, to me, is not any kind of a change. It is simply laying out the responsibilities very in a detailed manner of the existing code enforcement job. The parts that I had the concern about do they fit Crescent City, when you get into the technical parts that I really am not that familiar with, but I did notice there seemed to be some issues about interior locks, for example. Very, very specific.
And
Those
some-
things.
We may strike
Yeah,
those when we
and
get
some of
there.
that, when we get to it, we talked about that at the last meeting, that some of
Right.
that might just be far-reaching for us at this time, and so that's why we're trying to go through this and say, what do we feel like we can handle and what do we feel is far-reaching? And any time also that she's acting in her capacity as a code enforcement officer, it's my understanding, Bobby, that she is covered legally by the
Yeah.
city, and through our insurance policy and through legal, she would benefit from legal representation, correct?
Yeah, and as long as she was acting within her duties, she
Her
couldn't be sued
Yeah.
personally and there's sovereign immunity for the city representing her in her official capacity.
But again, Mayor, if I just could make one more comment. When we introduce an ordinance like this, or the comp plan, or whatever it is, I think it would be helpful for us to have a kind of an overview and explanation before we start, so that we don't cause people unnecessary anxiety in making them think that we're bringing in something that is a complete departure. I think the two issues that people have concern about are really covered. A lot of the explanation about what the code officer can do, that's the code officer's job currently. And then as well, we've identified a lot of parts where this very generic international ordinance, we have to comply with Florida law. And our city attorney has already explained to us that there is no entering property without a court order or demolishing a property without a court order. So we cannot impose something on our residents contrary to Florida law. We are protected by that
Right.
and the Constitution.
This just gives us the framework. This gives us, if you want to establish minimum maintenance standards, this kind of gives you the framework to go through, look at, and you can either apply it in its entirety, or like Winter Haven did, was it Winter Haven?
Winter Haven, yeah.
Winter Haven, and they took parts that just work better for their community. but it gives you kind of a framework to start with. That's what we're doing.
Question then?
Okay, we ready to start with chapter 2?
I just have
Just
another
one more
question then.
Yes, ma'am? Sure.
Diane Sykes, 04 Chestnut Street. If Pam can't enter a property without court order, how is she supposed to post a notice on that property? Or do other things that she has the authority to do if she can't enter the property without a court order?
No, it's not to enter. I mean, she can go on the property to post something, but she couldn't go inside.
Okay, so she can't go
And it might
into,
not be her, a building official would come in and condemn a building, and they have full authority to do that. Is that correct, Bobby, based in their scope of their job? If they deem it as condemned, they can come in and do that, and they would be the one posting that notice.
okay, I've just seen a lot of things about the interior and the plumbing and like, how do you make those kind of judgment calls from the street? That there's inappropriate sanitation or plumbing or, you know, the number of people that are in there. How do you make that kind of determination if you're,
That might be from a complaint, we may receive a complaint and, from a former tenant or something, and then you get to ask the building official to do an inspection. If they say the toilets don't work in there and they're going out in the woods, we can ask the building official to do an inspection.
Those things happen, you know.
And we've got that happening right now,
So
you know,
here's-
and so,
You'd be
yeah.
surprised really what's kind of going on in those
You get a
areas.
whole house without a permit.
Okay, thank you. Okay, let's
Ready for
start with chapter 2.
General requirements. The provisions of this chapter shall govern the minimum conditions and the responsibilities of persons for maintenance of structures, equipment, and exterior property. The owner of the premises shall maintain the structures and exterior property in compliance with these requirements, except as otherwise provided for in this code. The person shall not occupy as owner occupant or permit another person to occupy premises that are not in a sanitary and safe condition and that do not comply with the requirements of this chapter. Occupants of a dwelling unit, rooming unit, or housekeeping unit are responsible for keeping in a clean, sanitary, and safe condition that part of the dwelling unit, rooming unit, housekeeping unit, or premises they occupy and control. Vacant structures and land, vacant structures and premises thereof, or vacant land shall be maintained in a clean, safe, secure, and sanitary condition as provided herein, so as to not cause a blighting problem or adversely affect the public health and safety. That's pretty straightforward. Exterior property areas, sanitation. Exterior property and premises shall be maintained in a clean, safe, and sanitary condition. The occupant shall keep that part of the exterior property that such occupant occupies or controls in a clean and sanitary condition. Grading and drainage. Premises shall be graded and maintained to prevent the erosion of soil and to prevent the accumulation of stagnant water thereon and within any structure located thereon. Exemption, approved retention areas and reservoirs
What,
is the exception.
where are you?
Yeah, I'm
Yeah,
like,
this is section.
Section
general-
302.
Chapter 3.
Chapter 3.
We didn't go through definitions.
Oh, I'm sorry,
Yeah.
chapter 2 is definitions.
Okay, I thought, yeah, I'm going, I thought
I
we were.
can't find it either.
We're gonna go through the definitions.
All right.
okay, so
You're not going crazy.
In the
find
definitions, I think this is also someplace where we should put in there about our, code board.
Yeah, just, define, code people.
Yeah.
How's that?
yeah, well, we did that.
Which code is,
You want the definition?
No, I was following the definition.
I was too, and I was like,
That's why I know, but I'm-
well, wait a second, he's reading, his is very different from mine.
Cause he brought up
but
something.
the code official is the one that you want, it's on, page 2-1. And it's a code official, the official who is charged with the administration and enforcement of this code or any duly authorized representative. I guess we wanna make that, how do you want that to be? Do you want different code officials or?
We just wanted to define, the appeals boards, what we were, I don't see that defined here.
You
It's
just want to
not.
add it?
I don't
So
see it on here
we just
either,
need
but we
to
need
kind
to
of
add
add
it.
something
Add
here
appeals board,
to,
okay.
yeah.
We're gonna change the name from appeals board to code
To
board.
code, right.
I don't think we need to add it.
I got a question. I got a question on,
Yes, sir.
the portion over here about the grading and the draining of
Yes.
the road.
Yes, so you're gonna, yeah, we're back to where we were.
Yeah, right.
perfect.
Yeah,
Okay?
right. Now, I've been trying to get the city for quite a while.
I know what you're gonna say.
Yeah, to grade the road that I stay on just before you get, on around there and cut the grass so the garbage truck won't spread stuff and won't tear up the truck. And it seemed to be hard to get that to dig. Now, I was told that the county was supposed to do it for 9 months. County ain't got there yet. We got a sidearm, and they ain't got there yet. Now, can code be pressed against the city? No.
Can we use this against ourselves? Is that what?
But certain things need to take place. When you go around this curve, you know, some people say, well, the commissioner, yeah, but I pay tax too. Commissioner pay tax. And when you're going around there, that water sells on that road. And that's a draw for mosquitoes. They'll come out there, and I notice, I say, well, look at they're discriminating, and that's wrong. They need to maintain the property. Somebody else stay around there besides me. Got an old abandoned house around there, then another house on the other side. But regardless, it should be maintained. Now, I don't know what else to do.
No, I think this is.
What do we need to do?
I don't think this is this is not where we need to be discussing this.
Okay, well,
But I see your point, Tracy, and I, we were going someplace today, and we said the same thing you did in a different area, that the city needs to be better at maintaining certain areas.
Okay.
And that's something that we should bring up maybe, I don't know,
Thursday.
yeah,
Yeah, but
Thursday
maybe
in
we
the
need
commission
to-
meeting.
Maybe we
No,
need
I agree with you,
to incorporate that in here then.
yeah.
That we hold, these apply to ourselves as well. These apply to the governing board.
I know exactly where he's talking about, and I agree 100% with it, so I just don't think this is the forum today.
Okay.
But,
Yeah.
Mayor, I do have a question about this grading and drainage provision. It seems to me, the way things work in Florida, that it would be unreasonable for us to start making demands that people who already have had a permitted structure and have been occupying their premises to somehow have to, I don't know, it seems like grading and drainage are covered under permits to develop your property.
No, after the fact, I mean, you're gonna do it initially, but then there's a maintenance of those, once you've done those. I mean, you have to, with your permit, with your building permit, you would have to have that established, but then you're gonna have to have maintenance, and I think that's what this is talking about, that they shall be graded and maintained to prevent the erosion of soil and to prevent the accumulation of stagnant water. We've got several roads that have issues that are privately held, and there's some owners that don't want to do that, and there's other people that actually use that for ingress and egress, and they're subject to it, so,
And then we have our city roads, that same thing.
and then we have our city
Commissioner
roads
thanks.
that the city needs to maintain as well.
What
Need
I'm,
to be maintained.
what I'm talking about is private roads. So, I mean, I don't know, I'm not familiar with any jurisdictions that police people's private roads and make them bring fill dirt or whatever. I could see this causing a lot of grief and a lot of expense.
I don't even think this is talking about roads. I think this is talking about like your
Premises.
your
Premises.
property.
But so if you're on a property that slopes, all of a sudden we're gonna require you to fill it in? I mean,
No, I mean,
I think property washes
I
out.
don't,
If you have an erosion of your soil and it's causing,
I mean, legally, we may be able to do it. Personally, I think it's unreasonable, like you're saying, to just go in and make people read. But legally, I mean, I have to look into the legality of it, but I think that is a little much, because
This
then
one's tough. When
what
someone's
if
yard
somebody,
floods, we
they
can
come
say-
back to us and say, well, the reason I have water in my yard is because the city isn't cleaning the ditch or something like that, and then we get in a back and forth.
Right, I mean, Florida has very difficult topography, and for example, in some neighborhoods, we could permit a house next door and cause that to make water flow into a yard, blah, 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 blah. I mean, to me, this is very difficult, and as Bobby has pointed out, could open up all kinds of situations. I'm just not familiar with cities.
Do you have anything like this, Pam, that you ever deal with residents?
I think this is talking about if you have, your yard and it has a hole, say, and it's holding water, it's gonna breed mosquitoes and bugs and they're trying to prevent that. They're just telling you have to grade it so it doesn't erode. So to prevent erosion of soil and to prevent accumulation of stagnant water thereon. So if the water, if it rains and your water, your yard's washed away, it's likely to hold water and breed mosquitoes and things, so I can see where that would be a reasonable, request there.
Yeah, if it's a natural state, like when I grew up, our house, our yard always flooded just because the neighborhood was allowed to be built
Yeah.
there.
There you
And
go.
we played in the water, had a great time. But I think I could see, I hadn't thought of if somebody digs a big hole and then just leaves it and it fills up with water and mosquitoes, and we could say, you need to fill that in, that's not proper
It was due
grading.
to the grade of the property, and it wasn't, it says to here, premises shall be graded and maintained to prevent erosion. That would be planting grass or peanuts like you have out there.
Yeah, somebody has a
To
dirt.
keep the dirt from washing away and eroding and causing, something where it would have pool water.
It's
possibly.
washing into your neighbor's yard over and over again.
Well, I have an issue with that with the neighbor behind me, because that building, the water comes sweeping off of that and flows down, and it's my, that whole patio and everything, it just kind of caves in because of it, so we're having to put a drain in there to configure the water, because it's causing us some issues.
Right.
So, but that's something we're taking on ourselves,
Yeah.
so.
And then just, I would assume that it's legal because just a quick search, Bradenton, Florida has something similar, Boca Raton has something similar, Lakeland has something similar, Leesburg has something similar that prevents stagnant water in a yard.
And it says that an improved retention area and reservoirs are an exception, so I'm sure that's what they're referring to, is stagnant water. And maybe, it says shall be graded, maybe that, Bobby, maybe that premises shall be graded, do they all put that in there?
They're just saying that it's unlawful to have, basically because of the mosquitoes, like Pam was saying, that it's a mosquito grid, so it's unlawful after 24 hours after notice to allow stagnant water to remain in your yard. It doesn't tell them what they have to do to get rid of it, but that it would be unlawful and they could be cited as against their code.
So this is when we get into this, where we're trying to figure out what works for us and what doesn't work for us, and having this discussion.
Right, and
It's important.
actually, to me, I think the grading part is just, I don't know, I think that's very vague and is a lot to require of people. The issues, I understand the issue of standing water, nobody wants that. There's different reasons for it. But as well, something that we talked about, how do we protect our lakes? It's always concerned me, and this comes to, as Pam said, the maintenance, that we have quite a few dirty yards around here. And that's soil erosion. We're on a hill, when it rains, that dirt is going into the storm drains to some extent. So to me, I think some municipalities do not allow dirt yards. And that would certainly be a way to prevent that kind of soil erosion.
Well, I think I think this whole thing has to be talked about in general. There are always very specific things that happen, and you need to talk to people on how can we fix this kind of thing. But I think if we just take this for what it says, are we all in agreement that the premises, if it can be, okay, hopefully people can maintain it and they'll be graded and they'll be maintained to prevent the corrosion of soil and to prevent the accumulation of stagnant water. Can we agree that that is something that we should kind of move
I
forward?
think if we did this, I would recommend premises shall be maintained to prevent the erosion of soil and to prevent the accumulation of stagnant water.
Okay,
That's,
I mean, you know,
is
grading
everyone, how do you
can,
feel about that?
I think we all think
And
about
take the
roads,
grading.
you know?
Yeah.
Let's
And
not
take
think
the
about
grading
roads.
out?
Shall be maintained to prevent erosion, that's perfect, I like that.
I mean, I think grading could be as simple as a rake, but
Yes,
the word
yeah.
grading, I think of a grader,
That's the way I look
Yeah.
at it too.
like a big, because I think that may just, because all we want is them not to have stagnant
Stagnant,
water.
right, exactly.
No matter how they, well, by legal means, of course, but no matter how they get rid of it, whether they graded it or whatever else, however.
However you
you
do.
Okay, okay. Is
Okay.
everyone good with that?
Yes.
Okay,
Sidewalks
let's go.
and driveways. Sidewalks, walkways, stairs, driveways, parking spaces, and similar areas shall be kept in proper state of repair and maintained free from hazardous conditions.
Oh, well,
Now, I
right
have a
there.
question mark on that because most of all of our sidewalks are not in existence and the ones that are not in very good repair. I think there is.
Those are in the public right of way though, right?
Some of those are.
The problem though is Florida has a law where the person of the property is supposed to maintain those sidewalks. So when the sidewalks are in disrepair, the property owners are supposed to fix them.
I think this refers to on your private property, your
Okay.
front sidewalk, you know, is busted and tipped up and.
Because you say sidewalks, walkways, stairs, okay, then you should specify that. Because a sidewalk, to me, I have a sidewalk in front of my house, that's a sidewalk that I have to maintain.
Then maybe we want to put
That's a
on
separate, I think that's a separate
private.
issue. This is for premises and exterior property premises.
So I can let that sidewalk go in front of my house?
Well, we have a separate rule on that.
That's what I'm.
And
okay,
what is
so-
our rule on that? What
Right
is
now, I believe it's that the property owner is supposed to maintain, is that correct?
Sidewalks, yes.
Right, and I don't think it's state law, I think that,
I think it is.
no, I was gonna ask Bobby, but I'm pretty sure that it is a local option.
Yeah, when I worked in Eustis, they reversed it. Their city attorney advised that
Right.
the city needs to fix these sidewalks.
Right, most cities do not do what we did, and I had a conversation with Jay about this. Our sidewalk ordinance, I think, is problematic. You know, this is really a tough one, because quite frankly, a lot of people here have trouble maintaining their houses. This is gonna be a significant cost burden. I'm very concerned about how we are going to implement this.
What, sidewalks?
Well, the whole thing, sidewalks, driveways, similar areas, you know, blah, 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 blah. You know, I mean, let's face it, some people just have, you know, dirt driveways, they have sidewalks. I mean, houses are in disrepair. The whole issue of sidewalks and driveways is a whole nother issue, and they're not cheap. So I'm just saying that if we're going to require this, I don't know.
I thought we had, supposed to do so many sidewalks each budget year.
Well, I had recommended we use Better Place for that and
Right, no.
chip away at it.
Commissioner Betts, I'm talking about, this is talking about on people's private property.
Your private driveway.
I'm talking about,
Oh, you private, okay.
right, I'm
okay,
saying, what
okay.
I'm saying is if we're gonna say that your driveway has to be in good repair, or a little walkway that you have on your property, for people who can't even fix their property, how are we going to require them to fix their driveway?
This could be burdensome, is what.
Yes, very, very burdensome, because
Yeah,
we
right,
got,
okay, I see you talking about.
I'm saying, in the scheme of things, I would rather see us focus on the dwellings as opposed to, these other areas. because that's really your,
No, I feel like we need to look at the other areas too, because you've got rodent harborage, you have, weeds, I mean, that's all part of the
no,
exterior
I'm talking
property
about
areas.
for the sidewalk and driveway.
Okay, I thought you meant for there to be.
No, I'm with you on the road harborage.
Do you
all that.
want to exclude that?
Well, I-
2.3?
I would just say, that's an area I think we need to flag, because, when you're talking about, making sure that the structures are sound, this is a whole nother level of expense.
Well, you know what, when you have a vacant house, right now I can think of one in particular, you can't get up the stairs to even look at the house. Okay, you can barely make it to the stairs. Sometimes you need a machete. And, so in that sense, I understand what you're saying. I mean, it is very hard to maintain, but what we're seeing here sometimes in Crescent City is nothing is being maintained. The house, the lawn, the driveway, I mean, usually if the house is not being maintained, nothing else around it is either. So it creates its own kind of hazard.
I would say that if we wanted to keep this in here, sidewalks and driveways, shall be kept in proper state of repair and maintained free from hazardous conditions, and leave it at that.
You don't want to include stairs?
No, I meant, well, it says sidewalks and driveways, that's a title.
Oh, the time?
The title, yeah, I'm sorry. That, shall be maintained free from hazardous conditions. I mean, basically, that's what we're looking for, isn't it?
Yeah, because it can be hazardous trying to walk around some of these
I
properties.
had a sidewalk, this happened to me, I know some people would say, oh, well, I'm glad it happened to you. But, there was mold, it was the deer stuff,
Yeah.
and it was wet, and I was walking down her sidewalk, and it was cracked, and my feet went out from underneath me, and I hit my head on the back of the sidewalk. And it was something that owner knew. I mean, she said, oh, I should have told you, about that. You didn't see it because it was all covered up with stuff.
So are you saying strike through kept in proper state of repair?
Just
What
maintain
change are you
free,
recommending?
I think just to be maintained free from hazardous conditions at this point in time.
And
So
similar shall be
Strike.
maintained free.
Okay, strike kept in proper state of repair and, so the similar areas shall be maintained free from hazardous conditions.
Yeah. Does that make sense?
If everybody is in agreement with that, okay?
To me, I think I don't know, I think we may be going too far. I think maybe we need to revisit that, because there's a lot more that we're requiring, so.
And that's something, we're not voting on this is just something that I put a question mark to, that
Yeah,
maybe
I've
we need
got a
to do
question.
some additional research for communities such as ours and how they deal with something like this. And is this more applicable to, more of a gated community where they already have these established in there? So, anyway. Okay, let's move on to weeds.
Weeds, premises and exterior property shall be maintained free from weeds or plant growth in excess of what's our current standard?
We don't have one.
Okay.
We just have 10-20 that says all property should be maintained, reasonably maintained.
And actually, to me, I think that's sufficient. I mean, we have some wooded areas, we have, I think you're getting into more gated subdivision when you tell people what kind of plants they have. This says weeds or grasses and annual plants other than trees. I don't know. I think reasonably maintained covers it sufficiently.
Well, reasonably maintained, what you think is reasonably maintained and what I think is reasonably maintained are two different things.
And the same thing goes for code enforcement. If we had a different code enforcement, she might feel that one way is fine, and somebody else might come in and say, no, that's absolutely not. And so I think we do have to have something established. that gives some guidelines as to what is reasonable, because as with anything, it's all in the interpretation of the person interpreting it. So,
I'm not sure if we
What-
want to do this in height and inches.
yeah.
I'm just not quite
Yeah.
sure, what we should, how we
Charles,
should
what
do
is your
it.
recommendation? Do you have a recommendation on this?
Well, when it's quantifiable, then there's no argument. If we said in excess of 6 inches, then somebody says, my yard is not overgrown, we can either prove it or disprove it. So that's the advantage, that we actually set a height. So people start arguing about, you cited me and my yard is not overgrown. And we're not looking at someone's opinion. Well, in our opinion, it is.
Do we want to say weeds and grass and not necessarily plant growth?
Just weeds and, yeah, and grass.
Right, because, for example, I know one person in town has a beautiful wooded lot, and they maintain it for the benefit of birds and wildlife. And I don't think they want to be restricted, if you make people chop down their flowering vines and things that they have to attract hummingbirds. That just
We're not talking
doesn't seem-
about that, Lisa, we're not talking and telling them that they gotta chop down their flowers and all that kind of stuff.
No, but I'm saying that this is very,
There is a difference between weeds and flowers and,
And it says that cultivated
Yes.
flowers and gardens, the term shall not include
Yeah, it
cultivated
doesn't
flowers
include
and
any of
gardens.
that.
But I think with what you're saying, Commissioner DeVito, is that they keep it, it's more forested.
yeah.
Is that
Right.
correct? It's
That's
more
fine.
forested.
And that's fine and accepted.
And it's a vacant lot and it's forested and they haven't cleared it. But I think if we just put in there weeds and grass, that should take care of it. That's really what we're concerned with,
Yes.
is, weeds and grass. Now, is there something in here that, that as, you know, we've got some houses where the bushes around them have overtaken the houses.
That's kind of a different issue.
Well, that's what I'm saying, is if we have something in there that addresses that also. But for this, I would say that we just have on there weeds and grass.
Read that again, because you're gonna prohibit weeds and grass.
In excess of a certain height.
Yeah.
Right, and I think most cities, I thought we had a height limit, you have something to define overgrown.
We don't have any height on it at all.
No, that's what Pam said.
It's gonna be hard to put height, cause you got center-over-steam, and you got mahogany, you've got different type of grass in the yard.
Right.
But I think something this tall.
Yeah.
Oh, yeah, well, we
Yeah,
got too
when
tall.
it gets
From the
this
base
tall,
to,
yeah, when it gets that tall, and maybe that's something Pam, Charles, you can ask Pam to look at, other communities and what, if she can get an average of what other communities have.
So do you want
Okay.
10 inches,
Established.
12 inches?
We'll come back with it, let you know what they're doing
Right.
over there.
Yeah, let's come in with that, but I got mahogany in my yard, and I let it seed every now and then. So it'll come back.
Okay, so we want to move on to 302.5.
Right, but Mayor, before we move on to 302.5, there's a couple of things I have a question about as to whether this entire ordinance covers. And the issue that you just raised is one that I think is really important. I didn't see it in here, and I think we should make sure the issue where you said where the vines and the bushes are actually overtaking the house, that has happened a number of times. And I know if you have insurance, your insurance company will say something about that. But I think that's an important one, to make sure we find a place for it if it's not here.
Okay. Yeah, I have that noted to look for that too, so.
Okay.
So the next paragraph is the same thing, it's saying that we'll go in there and cut it, so that's, Bobby's gonna come back with that.
Okay.
Rodent harborage. Structures and exterior property shall be kept free from rodent harborage and infestation. Where rodents are found, they shall be promptly exterminated by approved processes that will not be injurious to human health. After pest elimination, proper precautions shall be taken to eliminate rodent harborage and prevent reinfestation.
That's fine.
Exhaust vents, pipes, ducts, conductors, fans, or blowers shall not discharge gases, steam, vapor, hot air, grease, smoke, odors, or other gaseous or particulate waste directly on abutting or adjacent public or private property or that of another tenant. So I guess that means they need to go straight up.
Okay.
Accessory structures, including detached garages, fences, and walls shall be maintained structurally sound and in good repair.
Okay.
Motor vehicles, except as provided for in other regulations, inoperative or unlicensed motor vehicles shall not be parked, kept, or stored on any premises, and vehicles shall not at any time be in a state of major disassembly, disrepair, or in the process of being stripped or dismantled. Painting of vehicles is prohibited unless conducted inside an approved spray booth. Exception, a vehicle of any type is permitted to undergo major overhaul, including body work, provided that such work is performed inside a structure or similarly enclosed area designed and approved for such purposes.
What does ours currently read, Pam? Does this cover that? I mean, is it similar to ours as it currently
We
stands?
have a code that says, vehicles have to be properly licensed, and, it talks about body, parts, not body parts, but, parts of the vehicle, discarded parts of the car.
Laying around, yeah.
Like-
Could have a transmission,
I was
an
thinking about
engine hanging
here
from
in
the
Cali.
tree.
Yeah.
We have someone that has lawnmower business, their front yard has parts and pieces and whatever.
Yeah, that would be, that's currently prohibited, I think, isn't it?
Yes.
Lawnmower parts and pieces. I think they've been cited.
Our code is very specific about, parts and disassembled vehicles and machinery and that kind of thing.
So do we want to substitute our language into this one, into this? Do you feel like?
I like our code better.
You like our
Yes,
code
yes.
better? Okay.
Okay.
And then if we can just go back to the grass thing, I just did a quick search. It looks like the most applicable thing that I found us would be Hernando County. I figured that's kind of a royal. It's 12. It looks like it's anywhere between 12 and 18 inches, and there's also exceptions for agriculture, anything zoned agriculture or conservation, or other exceptions that want to be made. So that looks like.
So this is 11 inches approximately. This is your paper. That's 11 inches. Put another one on top. That's almost 18 inches. Where would we like to be on that kind of scale? Do you understand what I mean?
Yeah. 7.
Yeah, that's what I was thinking. About 7 inches. I don't
So
want to
you're
be, I
thinking-
don't want to be 11 inches.
I don't think we're talking about the stalks, Bahia puts up those,
Yeah, just
Yeah.
one,
Stalks,
the
the
seed
seed
stalks.
stalks.
Yeah, but all
we're
that.
talking about the grass.
I think you drive by a yard and it's definitely, I mean, overgrown. Now, granted, they could be on vacation and right now the grass is growing like crazy. You could mow it twice a week.
Because when we left and came back, we had quite a
So,
bit of
Bobby,
grass.
do you think if we were to go 11 inches, hold that up again, please, Commissioner
Yeah,
Bird?
this is about 11 inches right here. Okay, from the bottom. That's how long the grass would be at, about 11 inches.
I don't think, it would be that tall.
It looks too tall,
You
yeah.
ain't
It's
riding,
too tall.
you ain't riding snakes.
Yeah, so, if you just take a few inches off the top,
Yeah.
and
Okay,
that's
I
3
guess
inches.
we can come back to
See what
this
I
if we
mean?
want to continue to look at it. Yes,
Yeah.
Commissioner DeVito?
My observation would be that there's plenty of areas on city right of way that get at least 11 inches or more. So, we've talked about the city, doing what we ask private property owners to do. I'm just saying if we're gonna let ours get a foot high, maybe we should have the same standard for,
We're going to place the same burden on ourselves.
yep,
Well,
because,
you would have to.
and it happens, I mean, this is Florida, it happens very quick. We have long days, lots of rain.
Well, and that's something that we need to bring up at a commission meeting, because right now I don't think we have enough public workers in order to maintain something like that. And to maintain, what Commissioner Banks was talking about earlier, we need more people to do that. So putting that burden, I think, on the city is wrong at this point in time. If you wanna hire a couple more people, well, maybe we can do it. But when you're talking about an individual that has to go out and mow their lawn, possibly once or twice a week, much different than one guy, okay, doing the entire city. So
Especially this time of year, like I
Especially
said,
this
where
time
they're
of year.
having to mow twice, I mean, you could mow twice, I could easily, I had mine done Friday, I could do it again today.
Right, well, that's what I'm saying.
So,
So,
You know, I think we just, the
We're
people
also-
that,
okay, so let's go back, let's move on, but let's
Yes.
look at, how to get an average of that.
Defacement of property. A person shall not willfully or wantonly damage, mutilate, or deface any exterior surface of any structure or building on any private or public property by placing thereon any markings, carving, or graffiti. It shall be the responsibility of the owner to restore said surface to an improved state of maintenance and repair.
Okay.
It's pretty simple. Swimming pools, spas, and hot tubs. Swimming pools. Swimming pools shall be maintained in a clean and sanitary condition and in good repair. Enclosures. Private swimming pools, hot tubs, and spas containing water more than 24 inches in depth shall be completely surrounded by a fence or barrier not less than 48 inches in height above the finished ground level measured on the side of the barrier away from the pool. Gates and doors in such barriers shall be self-closing and self-latching. Where the self-latching device is less than 54 inches above the bottom of the gate, the release mechanism shall be located on the pool side of the gate. Self-closing and self-latching gates shall be maintained such that the gate will positively close and latch when released from an open position of 6 inches from the gate post. An existing pool enclosure shall not be removed, replaced, or changed in a manner that reduces its effectiveness as a safety barrier. The exception, spas or hot tubs with a safety cover that complies with ASTM F1346 shall be exempt from provisions of this section.
okay,
I
That's,
think we currently have that as
yeah.
we require fencing of pool.
Standard.
and it says spas and hot tubs if we, as long as they have a safety cover, because that was my concern with this initially, is like, we have a lot of people that have spas that don't necessarily have a fence, but if they, as long as they have a cover over it.
well, and what is ASTM F1346?
It's probably back here in this,
I don't know, just,
it's listed in the back.
I mean, to me, I don't know that it needs to meet that number as long.
Probably, I don't know what it is either. It's
Performance specifications for safety covers and labeling requirements for all covers for swimming pools, spas, and hot tubs.
All right.
Okay.
I don't know, to me, we might just want to say an effective safety cover. But, you know, because it has to have labels, so, I don't know.
Section 304, exterior structure. The exterior of a structure shall be maintained in good repair, structurally sound and sanitary so as to not pose a threat to public health, safety, and welfare. The following conditions shall be determined as unsafe and shall be repaired or replaced to comply with the International Building Code or the International Existing Building Code as required for existing buildings. The nominal strength of any structural member is exceeded by nominal loads, the load effects or the required strength. The anchorage of the floor or roof to walls or columns, or the walls and columns to foundations is not capable of resisting all nominal loads or load effects. Structures or components thereof that have reached their limit state. Siding and masonry joints, including joints between the building envelope and perimeter of windows, doors, and skylights, are not maintained, weather resistant, or watertight. Structural members that have evidence of deterioration or that are not capable of safely supporting all nominal loads and load effects. Foundation systems that are not firmly supported by footings, are not plumb and free from open cracks and breaks, are not properly anchored or not capable of supporting all nominal loads and resisting all load effects. Exterior walls that are not anchored to supporting and supported elements, or not plumb and free of holes, cracks, or breaks, and loose or rotting material, are not properly anchored, or not capable of supporting all nominal loads and resisting all load effects. Roofing or roofing components that have defects that emit rain, roof surfaces that with inadequate drainage, or any portion of the roof framing that is not in good repair with signs of deterioration, fatigue, or without proper anchorage, and incapable of supporting all nominal loads and resisting all load effects. Flooring and flooring components with defects that affect serviceability, or flooring components that show signs of deterioration or fatigue, are not properly anchored, or are incapable of supporting all nominal loads and resisting all load effects. Veneer, cornices, bell courses, corbels, trim, wall facings, and similar decorative features not properly anchored, or that are anchored with connections not capable of supporting all nominal loads and resisting all load effects. Overhang extensions or projections, including but not limited to trash chutes, canopies, marquees, signs, awnings, fire escapes, standpipes, and exhaust ducts not properly anchored, but that are anchored with connections not capable of supporting all nominal loads and resisting all load effects. Exterior stairs, decks, porches, balconies, and all similar appurtenances attached thereto, including guards and handrails, are not structurally sound, not properly anchored, or that are anchored with connections not capable of supporting all nominal loads and resisting all load effects. Chimneys, cooling towers, smokestacks, or similar appurtenances not structurally sound or not properly anchored, or that are anchored with connections not capable of supporting all nominal loads and resisting all load effects. The exceptions are where substantiated otherwise by an approved method. Demolition of unsafe conditions shall be permitted where approved by the code official. That's a lot.
That's a lot.
But
That's
it
a
sounds
lot.
like it's all probably standard building codes.
Yeah,
Yeah,
it
I mean,
is.
it is
I
standard.
think that's what it is.
It's just, we probably have quite a few houses that that would fall under this.
You want a protective treatment? Exterior surfaces, including but not limited to doors, door and window frames, cornices, porches, trim, balconies, decks, and fences shall be maintained in good condition. Exterior wood surfaces, other than decay-resistant woods, shall be protected from the elements and decay by painting or other protective covering or treatment. Peeling, flaking, and chipped paint shall be eliminated and surfaces repainted. Siding and masonry joints, as well as those between the building envelope and the perimeter windows, doors, and skylights, shall be maintained weather-resistant and watertight. Metal surfaces subject to rust or corrosion shall be coated to inhibit such rust and corrosion, and surfaces with rust or corrosion shall be stabilized and coated to inhibit future rust and corrosion. Oxidation stains shall be removed from exterior surfaces. Surfaces designed for stabilization by oxidation are exempt from this requirement.
How do we,
This covers the houses that need painting, that are chipping and peeling, and it's beginning to rot the siding and so forth because of rains, swelling the wood and so forth. I can think of a couple of
How do
houses.
we, next problem is, how do we guard all this?
Well, in this case, we have let's say we have an abandoned house or a winter residence.
Or
It's
you
just
will be looking
peeling.
at just those owners?
Well, we look at everybody, but we say, you need to paint your house, and peeling, and the wood is starting to be, eventually the siding is gonna rot if it's a wood structure.
right,
This would provide us with that ability, because right now, it's not a building code violation that the paint is all peeled off your house.
so I know of a house that, I mean, I think this comes down to, and this is why, and I think we're gonna wrap this up pretty quick, take public comments before we do, and then wrap it up pretty quick, but this is one of those things that, I know somebody, the quotes that they've gotten, because it's peeling, you get into them having to scrape the house, that they don't have the means for it at this point in time. They just don't have the means for it. So what do we do what do we do? This is something we all have to think about. What do we do in that case?
Oh, could I just have one thing to say? And it's on the subject of the means and what do we do? I think one thing that we need to talk to the county about is what access the county has to the SHIP funds
They have
and
the SHIP
other,
funds.
right, and other Ford Housing Finance programs. Because I went to the League of Cities Policy Committee workshop that has to do with housing. We had a presentation, there are programs. So I would just put a star by this and put, I think it's incumbent upon us to see what public assistance is available. We have a dire need for that.
And the county does have that, and I think at one point in time, they had some citizens that took action with the SHIP program through the county.
Does SHIP cover painting though?
Not sure if it's,
I don't think so, you take it account.
I thought it was more
It's roofs
structural.
and
I thought it was more
windows.
structural,
Yeah, right, yeah, it is.
not cosmetic.
There's more than one Ford Housing Finance program. So, and that's what I'm really interested in, is to see, what the city can apply for. I asked, how can we find out what programs might be available to the residents of our city? And, they told me who we would contact about that. It's their technical assistance. But we have a need, I think, for finding out, about assistance for residents who just don't have the means to do some of these things.
Yeah, I agree with you,
Right,
Commissioner.
'cause- And of course, if it's somebody's homestead, you know, you're not gonna take that away from them.
No.
No, nor do we want to. I think,
Exactly.
I
Give
think,
them fines when they can't
Right.
afford to fix it to begin with, that's wrong too.
and I mean, and this is kind of like what we've talked about before, that it's, while we might be a little, some of this might be a little premature because we have other things to go, we've got to do this because we have to be prepared for what's coming in the future. And this prepares us for what happens in the future, and so, but right now, we have certain situations that are going to apply to this, that, you know, I personally, as much as I want everybody to take care of their home, there's also that side of me that understands, I mean, everything you do, I mean, regardless, it's $1,000, I don't care what you do to your house anymore, it's $1,000 or $10,000, you know? And so, and that's just, right now, that's difficult, so I think that's just, I don't know.
Well, there's more than one kind of occupancy. You have owner occupied, you have rental, you have vacation homes. So to me, I think in general, everything that's in here is good, but we need to make some kind of exception and also to see if we can find some kind of assistance for those owner occupied homes.
And I think it's the homesteaded homes are the ones that, you know, I would be most concerned about. The other ones, especially if they're a rental.
Right.
If they're a rental and they're making income on it, or if it's a commercial building, you know, that's a whole nother situation. Or it's abandoned, they've just walked away from an abandoned, they don't care how it looks.
At all, yeah.
That's probably a start.
Yeah, that's a start, you start there. And I'm absolutely fine with doing it if it's an abandoned building, or, you know,
Or it's someone's second,
or it's their second home,
Yeah, their second
yeah.
We'll pick it up here
Okay.
next time.
Yep, we'll do that.
Um,
This is a good
Maybe
spot
we
to,
can
it's a
schedule
good
another
spot to, okay, I'm gonna go ahead and open it up for public comment before we close it out, because I know that everybody's been sitting patiently out there listening to us go, go through this huge document, and we're not even, well,
We
we're,
made good progress.
yeah, we did, we're almost halfway through
So
it.
when we start back, we'll talk about light violation.
Whatever the next section was, yeah.
Yeah. So at this time, I'll open up public comment. Do you have something to say?
Just not trying to time here. Diane Sykes, 304 Chestnut Street. The question I have is in regard to 302.3, the sidewalks and maintenance of sidewalks by individuals. Some sidewalks in our city are part of the Florida Trailways. So is it incumbent on the property owner to maintain those? Specifically, I'm talking about like on Prospect Street. There are wide sidewalks where tree roots are breaking up the sidewalks. They're part of Florida Trailways. Who is incumbent to repair that? Is it the homeowner just because, because our city ordinance says sidewalks in front of your house are your responsibility?
well, you know, I was told when we moved in there, because we're part of that trail.
But I can't hear you.
Oh, I'm sorry, I was told when we moved into our house there, that the city was going to maintain my sidewalk. And I'll believe it when I see it, how's that sound? But anyway, you know, I'm gonna go with, it's probably gonna default back to that the person's gonna have to maintain their sidewalk. I mean, that's kind of where I'm at with it. Whether I agree or disagree, I don't know, but I think it's a burden to put on homeowners to maintain county sidewalks.
Well,
It's just
especially
my personal
if it's,
opinion.
if it's considered part of Florida Trailways, how can, you know,
I know,
But
it's
there's-
it's a good question.
There's maintaining by keeping the weeds and the grass and keeping it edged, and then there's maintaining if it's cracked and it's a tree root, so there's different levels of
And
maintenance.
I have a couple of issues, but those are my own personal issues that I'll bring to the city, because I'm a taxpayer too. And I will bring that to the city, but yeah, that's a very good question.
And, you know, I was kind of glad to see, that, the sidewalks down there in front of your church
Yeah,
fixed. I
Yeah.
think y'all had to pay for that.
yes, we did.
Yeah.
Yes, we did.
Yes, you did.
I
Oh,
will-
it was dangerous,
Right. and I
all
will-
along
I
that
wouldn't
side.
even go on.
It really was.
Yep, we fixed it, we paid for it, and for the question that Diane Sykes brought up about who maintains the trail, I have a very specific memory when that contract was signed, was brought to the city. I believe there's a provision in there, and we need to look at that, and that has been my question ever since. The state required the city to agree to maintain the entire trail. And there was a provision in there that said if the city did not maintain it to the standard required by Florida DOT, I believe, that Florida DOT could come in and maintain it and charge us for it. So it's somewhere in the contract for the multi-use trail.
And
Yeah,
that's,
I bet money that we agreed to maintain that, yeah.
Yeah.
Nope, we did,
Yeah.
we did.
but that's not all, I mean, so like on Prospect Street, that's one side. That's
Right.
the east side, it's not the west side of Prospect, I don't believe.
It switches sides when you cross
When
Central.
you use Cross
Well,
Central.
you do, but like
Right.
where your church was.
Oh, no, we don't have anything to do
I
with
know,
that.
that's what I'm saying, there's certain
No, but
areas where it's
Diane-
on that side, not this side.
Right, but Diane's question, I think, is one that I've had ever since that contract was signed. In general, our city ordinances say the homeowner is responsible, but we signed a contract with the state saying that we, the city, would maintain that. So the $64 question is, can we pass that off to the homeowner, whose property abuts the sidewalk? I don't know. I guess what I'm saying, in response to, Diane has raised a question that I've had for a while, and I don't know how to answer it.
Let me ask, wasn't that, the state was supposed to maintain it for 3 years, or eternal?
On the
I
sidewalk
think
or the
so.
medians?
The
Sidewalk.
sidewalk.
Oh, and for the
On
multi-use
the
trail?
yes,
I think we need to get that contract out.
yeah. I'm thinking it was just for 3 years. Somewhere, something of the state.
So it's been what, how long
Never
has
read
it been?
that.
3 years?
Yeah, I know I didn't need it yet.
Well, it's not, no, it's not been 3 years.
Oh, it been 3 years.
It was 2020.
Yeah.
Right, but I don't remember, I think we need to get the contract out, because I don't remember it saying 3 years, maybe it does, Commissioner Banks may be absolutely right.
Okay.
I don't
But it
remember
says
anything about the
Okay,
DDs.
do we have anything else for right now?
I
Thank
just
you.
want to encourage you to come to the Small Business Development Entrepreneur Social,
Headed over there now?
I don't know what to call that, building, the old bank building.
The old title company, old title bank and title, and
Yeah.
everything
Oh,
else, fire station, I think everything.
Yeah,
Ice cream, I think it was even an ice cream
Turn
at one
With a
time,
column on
big
the
shop,
corner.
so.
The
Turn,
building.
turn
the
to
diagonal doorway?
Where Ted Turner owns it,
Yeah,
where
it's
Ted
an
Turner building,
entrepreneur
where he
social
owns it
they do every
now,
month.
so.
Give it the name turntable.
What did you get?
Yes, it's turntable too, you're right, Commissioner Banks. Okay, and with that, I'm going to go ahead. Do you have, okay, go ahead.
Hey.
Sidewalks. Craig Sargent said that he's gonna pour, this is at Pine and Orange, that he's gonna pour all new sidewalks. Now, some of the old sidewalks are fantastic.
Yeah, they are.
We have a section maybe 7 feet. So I said, can I have your sidewalk? So if I were to clear that out, would the city move a section of sidewalk, the old sidewalk? I mean, is that a possibility?
That's a possibility.
Don't you need a permit to do sidewalks?
I don't know, I'll have to, no one's ever asked, offered to do a
Nobody's ever,
sidewalk.
nobody's ever tried to do a sidewalk. Matter of fact, I don't want a sidewalk in my yard, I don't have one.
I hate to see it broken up.
Yeah.
It is really, it's fantastic sidewalk,
No,
the old
thank-
sidewalk.
Yeah, it's the old sidewalk, some of them have writing in them, which I think the city has destroyed some of it, but I thought you needed to pull a permit to pour a sidewalk.
That
Right
would
away.
be, yeah,
You do for paving, but.
but concrete work, it would be concrete work, so
Yeah.
I thought you did have to do a permit for concrete work.
Well, particularly when it's actually on the city right of way. If you don't have to have a permit for that and meet standards, I would think we would want to do that.
Great question.
We'll meet back here Thursday at 4 o'clock. Everybody remember 4 o'clock?
Thank you.
Okay, with that, meeting is adjourned, workshop adjourned, thank you.